Please, your Lordship. Lordship, I need to mention item number 21. If taken consent of the Lordship, the other side, Lordship. Lordship, other side is also present, Lordship. Can the kindly be taken up after 2 weeks, Lordship?
Mr. What is your name?
May I please, your Lordship? Lordship, I have discussed with Madam Rita Devi, and it may be fixed on 22nd, Lordship. Yes, but if it is possible.
Fixed date, you may not get a fixed date. Heard, Mr. What is your name?
A.R. Tahbildar on behalf of R. Devi.
A.R. Tabildar appearing on behalf of Ms.
R. Devi.
R. Devi,
CGC.
London Central Government Council, who prays for an adjournment on the ground of personal difficulty. What is your name?
P. Major.
Also, Mr. P. Medhi, Learned Counsel for the respondent who does not oppose the prayer. 22nd June, possible? Possible. Okay, let this matter be listed on 22nd June.
Deeply applied.
Obliged, Lordship.
May I please, your Lordship? Your Lordship, listing of 2 MSc appeal for in orders column, your Lordship. Can it be listed on Friday? And orders?
Friday. Yes, okay.
Highly obliged.
May I please, Lordship? Lordship, I would like to mention one matrimonial appeal for listing, my lord. Both the parties, husband and wife, they have compromised the matter, my lord.
When do you want?
As per court's convenience, my lord. Friday, my lord, if possible.
Okay, fine.
Admission, my lord.
No, on Monday.
Monday, my lord. Highly obliged.
With regard to item number 20, my lord. My lord, there is an interlocutory application, my lord. That application I want to withdraw, my lord.
You want to withdraw?
Lordship. Petitioner does not want to press, my lord.
And what will happen to the make appeal?
Yeah, it will come for hearing, my lord.
Heard, Mr. V.K. You have informed the other side. Heard, Mr. V.K. Barua, Learned Counsel for the applicant. This will be in interlocutory application. Who submits that the applicant does not intends to press the instant interlocutory application and therefore he wants to withdraw the same. He submits that he has informed the Learned Counsel for the other side regarding his prayer, who does not have any objection. The prayer is accordingly allowed. This interlocutory application is dismissed on withdrawal. The connected make appeal shall be listed for hearing in its regular course.
May I please? I'm praying for listing of a IA civil in MSc appeal, Lordship. Next week on Monday, Lordship.
Next week on a date to be fixed by registry.
The IA is for withdrawal of the 50%.
Yes, next week on a date to be fixed by registry.
May I please, the Lordship? I beg to mention item 31 of the daily list. On the last occasion.
21.
31. 31 of the daily list. On the last occasion, notice was issued, but inadvertently we couldn't take steps. We'll take steps today.
What is your name?
L. Thakur.
Heard Miss L. Thakur, Learned Counsel for the applicant who submits that due to inadvertence, the petitioner could not take steps for issuance of notice upon the respondent. Hence, she prays for some more time for taking steps. The prayer is allowed. The petitioner shall take steps for issuance of notice on the respondent. How many respondents are there? How many respondents? Respondent by speed post as well as by usual mode within 7 days from the date of this order. Returnable on 13th of July.
May I please, your Lordship? Lordship, I am going to mention for listing 2 MSc appeals for orders
Next week on a date to be fixed by registry.
of that. May it please, Lordship? Lordship, I beg to mention for listing of MSc appeal for orders.
Next week on a date to be fixed by registry.
And item number 6 may pass over for 2 weeks, my lord. We have some instruction to take.
You have informed.
No, other side is not there.
Okay. Heard Mr. R.S. Chauhan, Learned Counsel for the appellant, who prays for an adjournment on the grounds that some necessary instructions are to be taken from the appellant. The prayer is allowed. Let this matter be listed after 2 weeks.
Obliged.
Yes,
Item number 1.
Well, today we are supposed to lead our argument, so the senior counsel each item is coming, my lord. Just start up in some technical. May I pray for just taking up this matter after some time, my lord.
we'll take it up after.
My part is over.
Yes,
Should I refresh once again?
no, we'll take it up after some time.
He's just coming, my lord.
Okay, okay.
I'm so, so.
Item number 2.
Made use of lordship. I have filed an IA in this case.
What I,
In respect of the order dated 7/4/2026, my lord, the case was proceeded ex parte because of my absence, my lord. Due to some health issues, my lord, I could not appear on that day. That's why.
where is the I? What is the number of I?
14442.
Yes, Mr. Vishwas.
Lordship, if your lordship kindly peruse your lordship's own order against which he has come. Your lordship has taken note of the past conduct of the parties, and on that day, there was no one present, there was counsel's name. It was there, but in spite of that, no one appeared, and in the past occasion also, your lordship had taken note of the thing. And suddenly.
Earlier, on one occasion, my lord. Due to
You
my-
want to cost to be imposed?
Yes, as your lordship, because the case is
Because-
pending, because
Because.
time and again, your
Health
lordship,
issues.
I understand he says that there is
I
a
could not
medical
appear.
thing, but no medical.
And ground of the council.
I have,
So council should pay the costs.
I apologize for the.
No, it would be,
In paragraph 2, my lord, I have stated in details, my lord.
heard Mr. S. M. Barua in IA. S. M. Barua, learned counsel for the respondent number. How many respondents are there?
1 and 2.
Respondent number 1 and 2. Also, Mr. A. Vishwas, learned counsel for the no, learned counsel for the opposite party / appellant. This application under Order 9, Rule 7 of the Code of Civil Procedure has been filed for setting aside the order dated 7/4/2026 passed in the connected FAO number 40/2024 to the extent it directed the appeal to proceed ex parte against the present applicants / respondent. Learned counsel for the applicant. Where is the reason?
Paragraph 2, my lord. Page 7.
Learned counsel for the applicant has submitted that on 7/4/2026, when the matter was called on for hearing, the engaged counsel for the applicant / respondent could not appear before the court as he was having some health issues. He submits that the ailment relate and the ophthalmological ailment with which the counsel was suffering made it impossible for him to appear before the court on the date when the matter was called on for hearing. He submit that there is no latches on the part of the applicants. It was only due to the indisposition of the engaged counsel for the applicant that none could appear before the court. Mr. A. Vishwas, learned counsel for the respondent, has objected to the prayer on the ground that that on the
On previous occasions also there was,
on previous occasions also there was default on the part of the respondent's counsel. So stop. I have heard learned, have considered the submissions made by learned counsel for both sides. It appears that at one stage during the pendency of the connected appeal, there was an attempt on the part of both sides to settle the matter amicably. However, the effort of settlement could not be materialized. Though there is a lapse on the part of the engaged counsel for the applicant slash respondent to appear before the court when the matter was called on for hearing. However, considering the grounds stated in paragraph number 2 of the instant interlocutory application to be sufficient ground which prevented him from appearing before the court when the matter was called on hearing, the instant interlocutory application is allowed, and the order dated 7/4/2026 passed by this court in FAO number 40/2024 to the extent it directed the appeal to proceed ex parte against the present applicant is set aside.
what's a similar order in CRPIO also because,
We'll pass a common order in both CRPIO and FAO common order. You are ready today? Now, what is the status?
there is no possible, because time and again attempt was made, he took as undertaking, but I don't think it has finalized with you. I think has been.
Only submission is that the entire dispute between the parties is related to some non-payment of running bills, my lord. Not that the total dues are not paid, my lord. Some running bills, there is dispute.
No, then pay that running bill. If
There is some dispute, my lord, regarding that.
resolve that dispute.
That's why I'm trying, my lord,
No, it has been quite some time, your lordship.
because the appellant
In FAO, what is the impugned order?
Lordship, because same, both are same. If I may request your lordship to take up
No,
CRPIO.
or we have set aside the order. We'll fix it next week.
Yes, sir.
Let the connected pass FAO number 40 as well as CRPIO number 177/2022 be listed for admission hearing on when choose a day.
19th, your lordship. Hearing day, it was possible.
Yes, Ramesh.
21,
11 May.
11,
11 में पार हो गए.
no, 11, 19th, I must.
19, 21,
Yes, sir, like case.
22.
No, hearing that, motion that 26.
26 to an order out there. 28 করে দিতে হবে।
On 20th, then your lordship, it is on Wednesday.
4th of June.
Okay.
My lord. Obliged.
Item number 4.
Yeah, teacher. This matter will pass over for the time being.
For the time, pass over.
Item number 5.
May I please, Lordship? Lordship, due to some technical issues, I pay for take over this matter at 2.
What technical issues?
Lordship,
Okay, we'll take it up at 2.
Item number 7.
5. Item number 5. Call item number 5. 2. Okay, 7.
Praise the Lordship. Lordship, my senior is in another court and we pass over for the time. Item number 7.
What is this?
We have filed an FAO and along with an IA civil.
After some time. 8. Call
Item
8.
8.
Paying a lordship, pass over the matter for the time being. If the PG government is on legs.
We are paying for the respondent claimant 1.
We'll issue notice. You have any objections? Heard Miss, what is your name?
People,
P. Fukan, learned counsel for the appellant. Learned counsel appearing on behalf of Mr. P. J. Burman, learned counsel for the appellant. Also heard Mr. R. Goswami, appearing for respondent number
1.
Respondent number 1/claimant. This appeal under Section 173 of Motor Vehicles Act 1988 has been preferred by the United India Insurance Company Limited, impugning the judgment and award dated 22/4/2025, passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, in MEC case number 2788/2016, whereby the appellant was directed to pay a compensation amount of rupees 5,28,400 along with an interest at the rate of 9% per annum to the claimant/respondent. I have perused the grounds stated in the memo of appeal. This appeal is admitted. Let the records of MEC case number 2788 be called for from the concerned motor accident claims tribunal. Let also notice be issued to the respondents. Since Mr. Goswami has already appeared for respondent number 1, no formal notice need to be issued to the said respondent. The appellant shall, however, furnish copy of memo of appeal along with the annexures to the learned counsel for the respondent number 1. As regards respondent number 2 and 3, the appellant shall take steps for issuance of notice upon the said respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 27th July, list accordingly.
Item number 9.
may I please give me, Lordship, here my appeal has been dismissed. MSC case has been dismissed by the court below, Lordship.
Your claim case has been dismissed. Heard Mr. A.R. Agarwal, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the appellant slash claimant, impugning the judgment and order dated 4/2/2026 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, in MEC case number 2065/2022. 2020, whereby the claims case filed by the present appellant was dismissed. I have gone through the memo of appeal and considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of MEC case number 2065/2020 be called for from the concerned tribunal. The registry to take steps for requisitioning the records. Let also notice be issued to the respondents. The appellant shall take step for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 29th of July.
Item 10.
May I please, your lordship? Your lordship, in this case also, the claim of the claimant has been dismissed.
Not Mr. D. Mondal, learned counsel for the appellant. Similar to previous order, the appellant shall take steps for issuance of notice upon respondents within 7 days from the date of this order, returnable on 17 July.
Next one was the item number 11.
Same order, 17 July.
Highly obliged.
12. Next number.
Item 12.
Please, your lordship. Let's say appeal preferred by the insurance company. Let's say there is violation of policy condition. The vehicle.
Mr. S.P. Sharma, learned counsel for the appellant. Cause title से देखना. Take steps within 7 days. Returnable on 17 July.
Obliged. Item 13.
No. Item number 1.
Finding item 1.
The side is not there.
Yeah, that is what, lordship.
We'll wait for some time.
Yes,
Let's
I'm waiting, lordship. No issue.
Mr. Borpujari may inform the other.
Let them come, lordship. I did
We'll
not want
take
to-
it. We'll take it up after some time.
Lordship,
13.
they have come.
Okay.
So first, I would like to raise two major points on technicalities, lordship.
Yes.
The first is, lordship would kindly come to the first page of the FAO, the clause title. So this is very vague. Lordship will kindly see an application. Have lordship got it?
Yes.
An application under order 43. Rule is missing. So under which rule of order 43, this application has been preferred. So I am not praying for dismissing their petition on this ground. Lordship may direct them to rectify it. There are, lordship knows, from A to W, 43 rule 1, sub-rule A to W, there are various provisions under which the appeal can be preferred. They have mentioned rule, but it is vacant. So let them clarify, because if they file it under different provisions of sub-rule, then on that ground I can raise the issue of maintainability again.
Yes. Yes, Mr. Kashyap. You are Mr. Kashyap. What is your name?
It's the bottom.
Gautam?
Complete bottom.
Navneet Gautam.
The instructions were effective, Lordship. So I was under the impression when my senior was here a few minutes ago, Lordship, because given that our part is done, Lordship, they have completed their submission.
No, the Rule 2 of Guwahati High Court Rules, Chapter 4, provides that you have to specify the provisions under which an application is filed. You have not specified it properly. So what are the consequences? Whether it is to be corrected, whether on that ground, though this may not go into the merit or roots, but whether it has to be ignored. And as the other side has raised the issue. Okay, what is the other technical ground?
No prayer. On that, I have some judgments also to place. That also can be curable. That both are curable defects.
Okay, on prayer part, make your submission.
Lordship. So if your Lordship is pleased to come to the provisions of Order 41. Yes. Forms of appeal. Order 41, Rule 1, form what to accompany memorandum. Every appeal shall be preferred in the form of a memorandum signed by the appellant or his pleader and presented to the court or to such officer as it appoints in this behalf. The memorandum shall be accompanied by a copy of the judgment. Provided that where two or more suits have been tried together and a common judgment has been delivered, therefore, and two or more appeals are filed against any decree covered by the judgment, whether by the same appellant or by different appellants, the appellate court may dispense with the filing of more than one copy. So that is regarding the certified copy of the judgment. Now, content of the memorandum. The memorandum shall set forth concisely and under distinct head the grounds of objection to the decree appeal from without any argument or narrative, and such grounds shall be numbered consecutively. So they are taking the plea that no prayer is mentioned here, stipulated here under sub-rule 2 of Order 41.
Yes.
3. Where the appeal is against a degree for payment of money, the appellant shall within such time as the appellate court may allow deposit the amount disputed in the appeal and or furnish such security in respect thereof as the court may think. So I'm not on that. So what is their contention? Their contention is that no specific requirement of prayer is needed in the appeal. This is a con. Now coming to ground 2, rule 2. Ground which may be taken in appeal, the appellant shall not, except by leave of the court, urge or be heard in support of any ground of objection not set forth in the memorandum of appeal, but the appellate court in deciding the appeal shall not be confined to the grounds of objection set forth in the memorandum of appeal or taken by leave of the court under this rule, provided that the court shall not rest its decision on any other ground unless the party who may be affected thereby has had a sufficient opportunity of contesting the case on that ground. So they can raise some grounds which are not part of the memorandum of appeal also. But in that situation, Lordship will give me the opportunity. Now, 4. Rule 4. one of several plaintiffs or defendants may obtain a reversal of whole decree where it proceeds on ground common to all. Where there are more plaintiffs or more defendants than one in a suit, and the decree appeal from the proceeds on any ground common to all the plaintiffs or to all the defendants, any one of the plaintiff or of the defendant may appeal from the whole decree, and thereupon the appellate court may reverse or vary the decree in favor of all the plaintiffs or defendant as the case may be. Here is the issue. Now, in the original suit, there are 7 number of opposite parties or defendants. And the present case, only 3 appellants are before this honorable court. If I am not wrong, it is 4. It is 3. Ohomia Protidin, Joyanta Boro, and Jotin Chaudhary.
Okay.
But there are Gaurav Gogoi, there are Jitendra Singh, and there is Mr. Baghel. Bhupesh Baghel. So if in our case, there are more than 3 defendants in the original suits and appellants also, there can be more. And the judgment covers or the decree covers all 7 opposite parties. So while Lordship will decide whether that relief which Lordship in case grants to the appellant herein, whether that will be applicable in respect of the 3 appellants herein or to all the 7 opposite parties who were part of the original suit. I am also placing Rule 31.
Order 41, Rule 31.
Rule 31. Content, date, and signature of judgment. The judgment of the appellate court shall be in writing and shall state point of determination, decision thereof. So basically, point of determination will take us to the various issues to be framed during the course of adjudication. So now Lordship will have to frame an issue. In that issue, Lordship will encompass all the 7 opposite parties or only the 3 appellants in respect of the judgment, which is under challenge in the appeal. So for that, they have to clarify. Because their prayer is silent. They do not have any prayer at all. If Lordship is pleased to come to their appeal memo, page 13, they have raised 10 number of grounds, but there is no prayer. So after the grounds, they straight away go to certificate and thereafter the plaint. So in this situation, Lordship will face the problem that whether Lordship's final judgment will cover all the appellants or the persons who are beyond the appellants. They are not at all indicating what relief they are seeking. And unless they seek a specific relief, how can Lordship decide what will be a relevant issue for adjudication? So Order 43 or 41, Rule 1 says grounds of appeal is required, no doubt. No arguments, no narrative is required. But although it is not written, in any kind of adjudication, they have to come before the Honorable Court in whatever forum it may be with a relief they seek. They have not filed the appeal for the sake of filing an appeal only. They want some relief from this Honorable Court. Lordship will be fine that we have got all the grounds, we have got a certified copy of the judgment, everything is okay. But they have to ask something. Without asking why, Lordship will give them. So again, I am saying here also, this is also not an incurable defect. It is a curable defect that is also indicated. Yes. Rule 3. Let us come to Rule 3 now.
Yes.
Rule 3, rejection or amendment of memorandum. Where the memorandum of appeal is not drawn up in the manner herein before prescribed, it may be rejected or be returned to the appellant for the purpose of being amended within a time to be fixed by the court or to be amended then and there. So they have not sought any, they have not made any prayer for amending it. Neither Lordship has granted them to amend it then and there. So it is curable. I am not seeking dismissal of the appeal. But they have to rectify so that Lordship will know.
Suppose they don't rectify, then
And that call is upon Lordship, because
Then-
that is what the other court immediately said, you do it or else I am dismissing it.
no, then it has, if I accept your submissions, then the appeal memo has to be rejected under order.
No,
Rule
Lordship may pass an order to give them time, granting them time to modify it or amend it. And if they do not do that within the stipulated time, then Lordship may dismiss the appeal. Lordship may give them an opportunity. 7 days, 10 days, whatever is convenient.
But provided the court is convinced that prayer is an,
Without prayer and without the first part, under which rule?
yes,
So these are two major technicalities I am raising, and in support of my case, I would like to place judgment.
yes.
It is very difficult to find a specific judgment on this Rule 41 regarding prayer, but general principles are laid down by the Honorable Supreme Court because this is very fundamental and nobody will come to any court without a prayer. It is just like going to a restaurant. They are showing me the menu, but I don't order which item I am going to have in my table. So the whole menu is given to us. But if I don't specifically mention, I want item number 3 and item number 5, they cannot do anything. It is identically here also. They have put 10 number of grounds. They have put the certified copy in place. But what they are asking, they do not know. And how can I argue? I have to address their arguments on a specific point, whether the restraint order should be against Gaurav Gogoi or against Proceeding. They have to specifically mention. They are silent during all the arguments. They have not mentioned about this point, that they want a restraint order only against Proceeding Group, their editor as well as the third person, the publisher. They are totally silent. Not a single whisper they have made before this honorable court. So Gaurav Gogoi is happy with the injunction order. Bhupesh Baghel is happy and Jitendra Singh is happy. And they have filed the WS and they have filed the objection regarding the injunction also before the court. And the matter is fixed tomorrow. And this order which is put to challenge, that was given a limited period of time till their appearance.
Where it is mentioned that.
It is mentioned, Lordship, if in order. Injunction order, Lordship will kindly come. Last page of the order, paragraph 13 of the order. May I read it, Lordship? Lordship will find that in
Yes.
page 106.
Yes.
Hence, an order of ad interim prohibitory injunction is passed restraining the OP's defendants for making, publishing, circulating, or disseminating any further defamatory statements or materials concerning the petitioner regarding the news item, very specific, not a general one. Regarding the news item published on 5/2/2026 in the Assamese Daily Proceedings, so and so, that is in court, till appearance of the OP's defendant before this court.
Oh,
Till appearance.
so after appearance, it automatically gets vacated.
But it has been extended, that is a different thing.
Oh, it was
It
extended.
was extended from time to time. It is extended till today. Tomorrow, the matter will be again taken up. And they are seeking time. We are appearing from every date. There is no prayer from us for seeking any adjournment. Lordship may call for the records also to that effect. So I will argue on merit also, but first I have to come to know whether they want a restraint order against Proceeding, Jayanta Barua and the publisher, or they want against Gaurav Gogoi also, Jitendra Baghel also, Jitendra Singh also, and Bhupesh Baghel also. Then only I can argue, because the reason is very simple. What in the press conference, Gaurav Gogoi and the two other political personalities were saying, Proceeding is just reporting. So in other words, they are not affected in any manner. They are not gagged. They cannot take the plea of Article 19G. That right of, what is that? Right of expression of speech has been curtailed. No. Whatever the three political rivals of the present respondent herein, Lordship, they said something and Proceeding was just reporting that. So Proceeding on its own did not make any commentary. Nothing is from their side. So those who are restrained from speaking against Dr. Himanta Biswa Sarma, they are happy with it because they know these are all falsehood they are resorting to. Another form of Pavan Khera. But here only one thing is that they do not have the documents. Pavan Khera made the documents also.
After 9/3, what was the next date?
After 9/3, Lordship, I'll just.
First date was 9th.
9/3.
And next date is?
Just 1 second, Lordship.
On that day, it was extended till.
Every time. 2 dates have elapsed, if I am not wrong. (29/4). After 9/3, 29/4.
Thereafter?
And then 14/5.
Tomorrow.
And in the meantime, they have filed a WS as well as objection. Gaurav Gogoi and his company. Or Gaurav Gogoi only. The statements were made by Gaurav Gogoi and there were some supplements from Mr. Bhagel and Mr. Jitendra Singh. And Proceeding just narrated what was said in the press conference.
Okay.
So they do not have any cause of action in my humble submission. We have made them party for the simple reason because tomorrow Gaurav Gogoi would have said in the trial that I have not made this statement. Proceeding has published it on their own to overcome that lacuna at a later stage, which may arise. Because in some cases, Akhil Gogoi always did that. That Sentinel did it on their own. So we have that experience. So just to take the stand that these were said by these three political persons and this was reported verbatim by the newspaper. Just to avoid, preempt their ground.
Apart from these 2
Techniques,
points on maintainability, anything?
No, Lordship, I'll place the judgment stand. Oh. Yes, Lordship has already said. So Lordship has actually, I was not aware of this rule that Gauhati High Court rules.
No, this I came across yesterday.
Lordship,
in a different case, therefore I remember.
Yes, I'm very obliged, Lordship. In every application presented to the High Court, there should be stated immediately after the clause title, the section and statute under which the application is made and the date of the order complained of and the value of the subject matter of the suit of which the application arises. If we go further, somewhere we'll find also that prayer is required. In plain, it is very specific in the CPC. Prayer has to be there. But here also prayer is required. Otherwise, how the court will know from what angle the issues are to be framed and how we have to argue. There can be now this order. Suppose they do not want the entire setting aside of the order, only regarding the long date that has been given, because this order was passed on 11/2 and fixing 9/3.
Yes.
Under the CPC, I have gone through it today that all injunction applications has to be disposed of within 30 days.
Yes.
So this next date is given beyond 30 days. That could have been a ground and they want an early date. That could have been a prayer that make it as short as possible within 1 week or 2 weeks.
Yes. They have not taken that ground.
That ground, no. Why I'm saying, so whether they want sitting aside of the whole judgment or some modification regarding the fixing of the next date. That can be another issue. That could have been a prayer in the appeal also. That this date is given beyond 30 days, which is against the CPC. CPC stipulates 30 days. So when 11/2, then the next date is 9/2, that is just 2 days before, but how can that be disposed of? So a shorter date should have been given so that the pleadings are complete for the hearing on the injunction. So why I'm saying there can be various verticals of the same judgment. One vertical is fine, that setting aside the whole judgment, but there can be multiple other angles, multiple other perspectives, which can arise from the same judgment. So they have to come before this honorable court with specific prayer. They can have the prayer of setting aside the whole judgment or make it implementable only against the other persons who are not before the court. That means the non-appellants. Now, the judgment which I'd like to rely. 2022 SCC online, Supreme Court, 9/28. In this case, this is not a writ petition, but this is Guardians and Wards Act 1890. So the basic principles the Honorable Court has laid. Paragraph 16, issue number 2. Coming to address the second issue, while this court is not apathic to the predicament of the respondent grandparents, it is a fact that absolutely no relief was ever sought by them for the change of surname of the child to that of first husband, sons of the respondent. It is settled law that relief not found on pleading should not be granted. If a court considers or grants a relief for which no prayer or pleading was made, depriving the respondents of an opportunity to oppose or resist such relief, it would lead to miscarriage of justice. This is what I am just arguing, that if I do not know what prayer they are seeking, what relief they are seeking, and I am not getting an opportunity to counter those prayers, then it will cause miscarriage to my client. 17. In the case of Trojan and Company versus R.M. Nagappa Chettiar, this court considered the issue as to whether relief not asked for by a party could be granted, and that too without having proper pleadings. The court held as under. It is well settled that decision of a case cannot be based on grounds outside the pleadings of the parties, and it is the case pleaded that has to be found. Without an amendment of the plain, the court was not entitled to grant the relief not asked for, and no prayer was ever made to amend the plain so as to incorporate in it an alternative case. In the case of Bharat Amratlal versus Doshu Khan Samad Khan Sindhi, the court held, though the court has very wide discretion in granting relief, the court, however, cannot, ignoring and keeping aside the norms and principles of governing grant of relief not even prayed for by the petitioners. So here the case of molding the prayer or relief is also not possible because they have not asked for anything. If they have asked wrongly a different relief, Lordship can modify it, mold it. There are a series of cases on that principle. And this case, which I am citing, Lordship, it is in respect of the Guardians and Wards Act, which follows the CPC. So the prayer has to be there. And some general principles, Lordship, I would like to place another judgment. 2010, Volume 1, SCC, page 234.
Yes.
Paragraph 29 and 30.
Yes.
May I read paragraph 29?
Yes.
The approach of the High Court in granting relief not prayed for cannot be approved by this court. Every petition under Article 226 of the Constitution must contain a relief clause.
This is in respect of
I'll come into the next paragraph also.
Yes.
Whenever the petitioner is entitled to or is claiming more than one relief, he must pray for all the reliefs under the provisions of Code of Civil Procedure 1908. If the plaintiff omits, except with the leave of the court, to sue for any particular relief which he is entitled to get, he will not afterwards be allowed to sue in respect of the portion so omitted or relinquished. Though the provisions of the codes are not made applicable to the proceedings under Article 226 of the Constitution, the general principles made in the Civil Procedure Code will apply even to writ petitions. It is therefore incumbent on the petitioner to claim all relief he seeks from the court. Normally, the court will grant only those reliefs specifically prayed for by the petitioner. Though the court has wide discretion in granting relief, the court, however, cannot, ignoring and keeping aside the norms and principles governing grant of relief, grant a relief not even prayed for by the petitioner. So there is no prayer to set aside the judgment or any other portion or amend the order under appeal. So in that case, it is totally confusing what relief they are asking and what relief this honorable court will grant. And at the same time, I do not know from what perspective I have to argue the case on the point of relief. Now regarding if Lordship takes up this matter only for this portion, then I stop. Or if Lordship wants to go to the merit, then I can go to the merit now. These are on the point of.
You make a brief submission on merit also, because I will dispose of the appeal.
Yes. So they are not, till now, they are not requesting this honorable court that give us some time to amend our petition number 1, as well as seek the relief.
Yes, their stand is that it is not
It
necessary.
is not required, the first part also, the first objection also.
Lordship, that is our stand. From what my senior had made submissions on the other days, our stand was Order 41 Rule 2 has a clear distinction that grounds must be there.
Okay, and regarding one more objection has been raised,
Lordship.
that your cause title does not properly indicate the provision of law in which, under which the appeal has been filed.
Lordship.
Order 43 contains several sub-rules. You have not specified the rule.
Lordship. I will not deny that there might have been some clerical error in this on our part. However, that does not nullify the case as a whole, Your Lordship. Your Lordship would kindly look into the matter where a certain ad interim order has been passed ex parte. And
No, I'm not going into those.
Lordship.
Hey, the respondent's plea is that you have not followed the procedure, the prescription of law in mentioning the relevant provisions under which appeal has been filed, since Order 43 contains several sub-rules. So he is not in a position to raise his objection. So, are you praying for rectifying, or you say that this does not go to the root?
Lordship, what instruction I have from my senior is that if senior counsel Mr. Sekia makes his submissions on merit and whatever submissions he makes, we will make a rejoinder submission to it at 2 p.m. Once senior counsel is done with his submissions, my senior will be making his submissions on the basis of that. And he can clearly answer all of it, Your Lordship.
And regarding the preliminary objection, that are you seeking any leave of the court to rectify the cause title? Or is it necessary according to you? What is your submission on that point?
Lordship, to be really honest, Your Lordship, perhaps I'm not in a position to explain my stand on it without my senior's instruction, Your Lordship.
Okay, we'll hear you on merit. Be brief on merit.
After my learned senior is done, Lordship may take up the matter at 2 p.m. And
let us see what submission comes. Mr. Saikia, try to be brief.
Because if I have to, but I have to place the plane. I'll take some time, not very long,
Okay.
because that's why I want to avoid on merit. Because if I enter into the merit, then I cannot leave anything.
Yeah.
Or Lordship may hear them on this point, then
No, but what indication I'm getting that they are not conceding on
They're
that?
very nice, Lordship. I welcome that also, which will be in my favor. If they, after getting the opportunity from the court also, they are not taking it, fine, Lordship, then I stick that this case is not maintainable and it should be dismissed in limine. That submission may be recorded. Dismiss in limine. That means without entering into the merit. But as Lordship requested me to make my submissions on the point of merit, Lordship, I'll try to cut short.
If we come to a finding that prayer is a necessary,
Then Lordship may not be able, because Lordship is taking it for final disposal.
no, make me clear. If I agree with your submission that prayer has to be there in memo of appeal and it is not there, therefore, then this appeal has to be rejected under Order 41 Rule 3. Then only rejection of appeal.
In that case, I do not know Lordship's mind, but let me now, if Lordship allows,
No, I am not making up in my mind at this stage.
I'm not,
I'm
because they are not taking that opportunity of rectifying it also, which is permissible under the code. If they are not doing
no,
it,
I just want, what is your submission? Is whether if the court comes to a finding that appeal is a mandatory requirement, then whether the appeal should be dismissed or it should be rejected.
it should be rejected.
Yes, memo of appeal. Because procedure of rejection is already there in.
Rejection, or yes, Lord. Rejection.
Okay. Now you make your
It is
submission on.
very specific rejection, what is there.
Okay.
So, on merit, Lordship, what is my case? My case is that in a press conference, 3 persons from the opposition political party said and made some statements which in the submission of the respondent herein, Lordship, whom I am representing, felt that there is no basis. They have taken resort of falsehood, and a false narrative was attempted to be created prior to the election, just to misguide and mislead the people of Assam in the forthcoming election, which was scheduled to be held in the month of April at that point of time. So, if Lordship is pleased to come to page 32.
Yes.
What triggered for filing of this plaint? That on 5th February 2026, the above named respondent 4 to 7 published that the 4 to 7 are the appellants herein before. Published 2 news items under the heading Rajyot Name Bename Sampoti Kroy Mukhyamantri Poriyalor 12,000 bigha bhumi. Number 2 heading Himanta Biswa Sharma Karu Nohoy Jare Ghonishto Hoise Tare Pithit Suri Bohuaise. In the first page, page number 1 of Ohomia Proceedings in the Gauhati edition of the newspaper, the said news items written by Gauhati-based staff reporter Proceeding Songbad of the newspaper, whose name has not been disclosed, was prepared as indicated in the news item itself on the basis of certain remarks made by the defendant number 1, 2, and 3, that is Gaurav Gogoi, Jitendra Singh, and Bhupesh Baghel, in a press conference addressed by them jointly at Gauhati on 4/2/2026 at Rajiv Bhavan. In the said news items, both dated 5/2/2026, the defendant number 1 to 3 made some remarks against the plaintiff herein and his wife, including statements specifically naming the plaintiff herein as the chief minister, that is plaintiff and his wife are occupying 12,000 bighas of land in the state. Specifically quoting the defendant number 1, the news item reported, which is translated into English as Chief Minister Himanta Biswa Sarma purchased such amount of land in the nook and corner of the state in the name of his wife and other family members, and the exact amount of which is still unable to be quantified. As reported in the said news item, the defendant number 1 further alleged, as reported, that the plaintiff herein is impolite and arrogant chief minister, family businessman, land grabber, most corrupt chief minister, traitor, betrayer, politician, the chief minister of all time. In the said news report, the defendant number 2, namely Bhupesh Baghel, has been quoted as saying that the plaintiff herein is a master fraudster and he has frauded all his inmates, and the gang, including his wife, has plundering in Assam. As has been reported in the second news item under the heading, Himanta Biswa Sarma Karu Nohoy Jare Ghonishto Hoise Tare Pichit Suri Bohuaise, the defendant number 2, that is Jitendra Singh, has been quoted as has been saying, Himanta Biswa Sarma has said, has sold Assam. Himanta Biswa Sarma and his family is doing family business by selling Assam. He further has been quoted as said that the plaintiff and his wife have brought in their name 12,000 bighas of land. Plaintiff herein stabbed a former chief minister and became chief minister through backdoor. Plaintiff herein has imposed HBS tax in the state. There is Louisburger, Sarada, PM Sampada, North Kachar Hills scam against the plaintiff, etc. According to the plaintiff herein, such remarks made by the defendant number 1, 2, and 3, published by the other defendants being defendant number 4 to 7, by any standards are extremely defamatory and derogatory. The newspaper Ohomia Proceedings, while publishing the said defamatory items, both dated 5/2/2026 under the headline so and so, clearly indicated that the statements quoted in the news items were made by defendant number 1, 2, 3 in the press conference addressed by them jointly at Gauhati on so and so. Then the newspaper report is annexed therein. Then coming to paragraph 9. What are the basic things which are considered to be defamatory while filing the title suit? In the aforesaid defamatory news items dated 5/2/2026, written, printed, published, and circulated by above named defendants 4 to 7 in their newspaper Ohomia Proceedings with the heading so and so, reprehensible insinuations has been casted upon the plaintiff herein, leveling allegations and accusations which may be summarized as under. Number 1, plaintiff and his wife have brought in their names 12,000 bighas of land. So they are very specific that plaintiff and his wife purchased 12,000 bighas of land. Number 2, plaintiff and his wife purchased such amount of land in the nook and corner of in their name. So very specific, in their name, and the exact amount of which is still unable to be quantified. Plaintiff herein in an impolite and arrogant chief minister, that is a subjective, so I do not want to make any comment. He is a family businessman and land grabber. So this is a very dangerous statement, land grabber, which is a criminal offense. Most corrupt chief minister, traitor, betrayer politician, he is the liar chief minister of all time. So very specific adjectives are used here. Plaintiff has sold Assam. So Assam was put to sale and the chief minister has sold Assam. Plaintiff and his wife are doing business by selling Assam. Then plaintiff herein stabbed a former chief minister and become chief minister through backdoor. Though a democratically elected chief minister, they are alleging that he has backstabbed the former chief minister. Then plaintiff has imposed HBS tax in the state. We have not heard this word before, but now it is in their statement in the press conference. The plaintiff is involved in Louis Berger, Sarada, PM Sampada, North Kachar Hill scams. Not a single document is there regarding this. So now the defense, because the Honorable Court has taken our defense, from which the prima facie case was made out that these statements are defamatory in nature. So this paragraph I would like to read out. Paragraph 10. The plaintiff herein specifically and categorically denies all the above stated allegations and accusations made by defendant number 1, 2, and 3, not the appellants herein, Lordship. Our whole case is against Gaurav Gogoi, Bhupendra Baghel, and Jitendra Singh. All the stated allegations and accusations made by defendant number 1, 2, and 3 in the said press conference dated 4/2/2026 and reported and disseminated by other defendants in the Ahomia proceeding dated 5/2/2026 under the heading so and so. It is categorically denied because all these allegations are false, frivolous, fabricated, concocted, and without an iota of truth. As regard the allegations of the plaintiff has purchased 12,000 bighas of land in the nook and corner of the state, the plaintiff herein categorically denies the same, terming the said allegations as totally false and absurd. The plaintiff, being a public servant, is required to submit all his and his wife's property details to the government other than in the affidavit submitted during the time of contesting assembly elections. All his property details are also mentioned in his income tax return files, which are available in public domain. Further, the plaintiff and his family members' property details are also reflected in the record of Register of Companies. The defendant, before raising any such allegations, could have and should have verified those details. But the defendant, without ascertaining the property details of the plaintiff and his family from the documents available in the public domain, raised those allegations only for the purpose of defaming and disreputing the plaintiff herein, knowing fully well that these allegations are false and without basis. The plaintiff states that the property owned by the plaintiff and his wife have been acquired through legal means only, without resorting to any illegal or unauthorized way, and all properties purchased or procured are duly accounted in the records of the Income Tax Department. So they are saying that these are properties purchased in their name. So everything what is in their name are all recorded in the Income Tax Department election petition, election affidavit, as well as the declaration to the government. Election Commission as well as the concerned Department of Government of Assam. So in 3 government authorities, all the details are available and all are declared, whatever is there. That means these are all legally acquired property, duly accounted for, and all whatever procedure has to be followed, everything is followed. So these are properties procured through what means. It is categorically stated that not a single property of the plaintiff or his wife can be put in the category of benami properties. We have a specific denial. They can say that without my name, but there are allegations that it is in the name of the plaintiff as well as his wife. And he has very categorically said that whatever is there in their name are properly and duly declared before the Income Tax Authority, before the Register of Companies, before the Election Commission in the affidavits. These are statutory authorities. And he has also categorically denied that there is any property which can be put into the category of benami properties. That means without name. In other words, the plaintiff and his wives are owners of properties acquired through legal and permissible means without indulging in any kind of illegal and corrupt practices. The defendant number 1 and 2 miserably failed to mention about any property which the plaintiff or his wife have acquired illegally through corrupt practices, and they are simply attempting to create a narrative to damage and destroy the image of the plaintiff in the eye of general public in order to gain political mileage in the ensuing state assembly elections. So this was their game plan. That they will create a false narrative, just like Hera had done just 3 days before the polling. Here they have done 4 days or 10 days before the model code of conduct and announcement of the election. That was on 5th. Election was declared on 15th of March. So this was a game plan of a political party. Further, it is also categorically denied that the plaintiff and his wife brought in the name of 1200 bighas of land anywhere in Assam or outside, and accordingly their allegations are totally devoid of any merit and thus defamatory and derogatory. So here they are saying that 1200 bighas of land are standing in their name. At least they have not fabricated any false title deeds, unlike Khera. What Khera has done, he is facing the music now. And these people are one step smarter because they have not manufactured any documents. They have only said orally, without any basis, without any materials, without any documents. But Pawan Khera did the mistake of making fabricated documents, fake documents of three passports and the properties in Dubai as well as properties in or corporate investment in USA. So here, the difference between Pawan Khera and these Gaurav Gogoi's cases, this was 1 month earlier, so they did not made any documents. There was no documentary evidence, and there's a stay order. Pawan Khera became smarter because they have seen that without documents, people don't believe. So he made those documents just to convince the electorate just before the polling dates. And the results, Lordship says, it did not have any effect, and the government and as well as the parties acted promptly. So he had to run for 25 days. And today I have come to know that from Egypt also the response has come that all those documents were fake. Dubai has already given it. Next paragraph. The plaintiff herein also categorically denies that he has indulged in any land grabbing. So this is a very serious allegation. If there is a land grabbing case, Lordship, there is a land grabbing act also. At least they should have furnished an FIR or some complaints that my land has been grabbed by Dr. Himanta Biswa Sarma.
No, his main objection of the other side is that while granting ex parte.
I'll come to that. That is why these are the materials.
Okay.
That these are the materials on the basis of which the Honorable Court came to the conclusion. These statements are made on oath by a responsible person of the state. Whatever he is stating herein, because I do not have any land of 1200 bighas in my, what document I can produce? They are saying that I have to produce documents. That means they are asking something which I do not have. That I have 1000 bighas of land or I have 500 bighas of land.
You can only deny on oath.
I can deny only.
On oath.
They have, the onus lies on them. They are saying, not the appellants, they are reporters only. Those who are alleging, they have to furnish documents that this is the title deed of 12,000 bighas of land standing in the name of Rini Kikuya.
No, one of their submission was that while granting injunction against the fourth state,
the balance of these three conditions have to be
only in exceptional cases ex parte injunction.
That is why I'm making my foundation. That's why I said on merit I have to make my foundation on the basis of which the learned trial court granted the ad interim injunction, and I will try to justify how he is right in his decision making process. This is an exceptional case. Just before the election, you say all wild allegations. By the time the documents will be verified by the court, at that point of time, the polling will be already over. What was the game plan of Khera? And
so timing is relevant here.
Time is crucial. Time is very much crucial. This was done in the month of February, first week. 15th of February, the election was announced. The run-up to the election. They wanted to create a false narrative. And the learned trial court has rightly stopped them from indulging of this kind of misadventure by spreading wild allegations. And they could have got the stay vacated on 9th of March by producing the documents. The court gave them an opportunity. Single complaint of land grabbing case, they should have been able to place before the court. Forget about 1000 bighas. Let them produce documents of 100 bighas also. Or 1200 bighas. Only 100 bighas also in their name. Whatever landed properties, there are hardly few bighas which they are getting from their parents are there in their name, and those are reflected in the affidavit submitted in the Election Commission's portal at the time of participating in election, number 1, in their income tax returns, and number 3, the declarations they have to do by all cabinet ministers, government officials in the government department. 3 statutory authorities are having the records of their property. And they are not saying that they are acquiring or they are having Benami properties. Benami properties they have not said. They said in their name. And Benami also has been denied. So may I continue, Lordship? Now,
The counsel for the appellant has not gone into merit. His main thrust.
I have to, because
His main thrust was, before granting injunction, the publication house should have been given an opportunity of being heard. That is the main thrust.
then the concept of ad interim injunction or interim relief
He
on the
really-
very
he-
day of motion, this will have no place in our criminal
Yes,
proceedings.
and he was mainly relying on that judgment in Bloomberg case.
I'll come. That is, their judgment helps me.
You addressed that.
I will, no, Lordship, I cannot, because I am fighting a very serious case.
Okay.
So if Lordship wants to have it on some other day, I can continue.
No,
And I
I'll,
have cancelled my travel today for
I'll,
this
I'll
case.
dispose it of today. I'll try to dispose it of.
That is, then Lordship will have to give me time, because
Okay,
I cannot curtail my time, and
Okay,
I do not want to do injustice to my client.
Make your submission.
And I have cancelled. I was supposed to go to a very important meeting today. I cancelled it because I promised this honorable court that I will make my arguments today. I wanted to do in Monday also.
Try
The others-
to be as brief as possible.
For establishing an exceptional case, I am placing all this. Next is that land grabbing case. So they do not have any documents. Next one is, there is no such imposition of tax in the state as HBS tax. And therefore, the said allegation of the defendant is not only a figment of imagination, just to destroy the image not of the plaintiff, but of the entire economy of the state, which is now progressing in a very rapid manner. Next is, as regard the allegations of plaintiff's involvement in Sarada, Louis Berger, PM Sampada, North Kachar Hills, it is categorically denied. In fact, plaintiff was never involved in any of the said scams at all. Further, the plaintiff has been a part of investigation in the Sarada incident as an witness only and not as an accused.
Okay.
So the charge sheet is before Calcutta in Alipur court. His name is there as a witness. And that statement, Lordship, we have produced before the court from the investigating agency, that Lordship will find, because they are saying that we are also relying upon newspaper report. That is relevant. That is why we relied. Page 62. Lordship will see. Page 62. This is NDTV report. 5th November 2018 statement. CBI denies questioning Assam Minister in Louis Berger bribery scam case. CBI spokesperson R.K. Gore dismissed report that Sharma was questioned by the agency in connection with the case as reported by some news organization. The CBI Monday denied report that it has questioned Assam Minister Himanta Biswa Sharma in connection with his probe into the multi-crore Louis Berger bribery scam. CBI spokesperson RK got dismissed report that Sharma was questioned by the agency in connection, so and so. No such questioning has taken place as reported in a section of media. In its order dated 1, so and so, the CBI should take over the probe. It alleged that you adopted. So in this case, he was a witness in this case, totally he is not involved. In Sarada case, he is a witness. So in Louis Berger, he was not involved in either as a witness or as a accused. So all these false statements, in fact, when Tarun Gogoi made identical statements, there is a restraint order till his death. We have withdrawn the case after his demise. So politically, they play these games. But when they play the games, they must have the materials. In 2015, the Learned Trial Court passed an injunction order against the then Chief Minister of Assam, Tarun Gogoi. He made identical statements, and that statement was alive till 2023, that injunction order. Trial was continuing. So without materials, if they play these games, then they will have to face the music. Next paragraph. It is in Sarada case, the plaintiff was not even an accused, he was only examined as a witness. Further, it is Louis Berger case, CBI office themselves has clarified that in the year 2000, denying even questioning the petitioner. So he is no way involved with any of these scams. Now next. Further, it is stated plaintiff being a democratically elected member of Assam Legislative Assembly and duly elected by the MLAs of the NDA Alliance as the Chief Minister of the state, there is no question of becoming Chief Minister through backdoor, stabbing a former Chief Minister. Only purpose of raising such allegation is to defame and distribute the plaintiff. So when Dr. Himanta Biswa Sarma Lordship became the Chief Minister in 2021, the legislative party of BJP had a meeting, just like 2 days before they had a meeting. In the meeting, they have chosen him as the leader. In 2021 also identical exercise was done. So there is no question of backstabbing. It is a democratic process. Suppose Congress got 80 seats this time. They would have a meeting of parliamentary committee and they will choose the leader, and that leader will go to the governor to state claim for forming the government. So there is no such thing as Brutus or Macbeth or backstabbing here. It's a democratic process. They may like, they may not like, but who is having the support of the majority of the persons? For the electoral, it is the citizens, and for this kind of positions, the MLAs. So in representative capacity, they give the verdict, who can be the leader. So this kind of false narrative they are trying to create at the time when the election is coming, just to defame and bring into disrepute the image of the plaintiff. So he has no other options but to go to the court and knock its door. Of course, with a prayer, not without prayer. Therefore, the allegations and accusations made by the defendant against the plaintiff are nothing but false statements of facts, and the same are uttered by the defendant knowing fully well that these allegations are not at all true. Accordingly, these allegations are not only false but concocted, misleading, absolutely baseless, without an iota of truth, and the same has been made and published with a malafide intention of causing severe damage in the name, reputation, etc. Then, regarding the plaintiff, whatever was said in the press conference, the duty cast upon them also to verify before reporting. Those things are written in paragraph 11 and 12. They, under the basic principles of journalism, Lordship, when a news has to be written against me, it is the bounden duty of the newspaper agency or the reporter to ask me whether this is false or not, whether Gaurav Gogoi has said that, what is your response to that. Those things were not done. So these are narrated here, not verified. They could have also verified whether Himanta Biswa Sarma and his family is having 1200 bighas of land from the records, whether there is any case against Himanta Biswa Sarma in respect of the 3 scams they are mentioning. All the records are available in public domain. whether there is any existence of HBS tax, we have not heard. We heard GST, AGST, VAT, all these things, income tax. But HBS tax, this is their figment of imagination. So the verification part, the appellants have not done. So we have basically repeated the same things in paragraph, all these paragraphs. So when the case was argued before the Honorable Court, we have placed all these things along with the denial of the CBI officer and we have prayed before the Honorable Court that one prayer is to declare the said news items under so and so as defamatory and has harmed the name, fame, reputation, and goodwill and future prospect of the. So we want a declaration, page 47.
Yes.
Basically this, and in the interim, we have also prayed that there should be an injunction. There is a separate petition for that. A miscase was filed. The Honorable Court thereafter was pleased to pass the order on 11/2/2026, page 91.
Where is the injunction application?
And then page 65. Page 65, application filed under order 39, rule 1 and 2, read with section 151 of the code of CPC, civil procedure. Page 87. Page 87, the prayer portion there. And in paragraph 38, we have stated
No, how the
affected, it will affect.
how the object of granting an interim injunction would have been defeated if notice.
Yes.
Because of the timing. How you have justified the statement which you made in para 38 of your injunction application?
Paragraph 32.
32.
No, 32. 36. That the plaintiff has been able to establish a strong prima facie case. Beside, balance of convenience lies heavily in favor of the plaintiff of being protected with adequate interim relief as prayed for herein. Further, in the event of petitioner being not protected in the interim, as prayed for, the plaintiff shall suffer irreparable loss and injury, and as such, three golden principles required for grant of temporary injunction, namely prima facie case to go for trial, balance of convenience, and irreparable loss and injury being present as a chain in the instant case, has filed application under order 39 1 and 2 for issuance of temporary injunction against the petitioner. And we have also at paragraph 38, it is stated and submitted that the object of granting ad interim prayer would be defeated by delay if the notice of the same is served upon the opposite party's defendant. As such, the notice required under order 39 rule 3 of the code may be dispensed with. And paragraph 34, the plaintiff petitioner states that the opposite party defendants may make further statements.
Yeah.
34, page 86. The petitioner states that the opposite party defendants may make further statements or may publish further news item against the plaintiff containing defamatory materials, and therefore opposite parties defendants are liable to be restrained by issuing permanent prohibitory injunctions, thereby restraining them from publishing any further defamatory statements against the plaintiff petitioner. Moreover, the opposite parties are also liable to be directed to publish clarification and apology in their newspaper by issuance of permanent mandatory injunction. And we have
Okay.
also reserved our right to file additional documents in support of the averments. Paragraph 33.
Okay. Anything?
Then I'll place the judgment, Lordship.
Yes.
So Lordship is maybe rising person is waiting behind. If I can continue, I can continue.
You continue.
Okay.
It's okay.
Page 91, Lordship. So I'm not placing any of this paragraph initial because the Honorable Court was pleased to record whatever was there in the plain. Then paragraph 6. Now on perusal of the plaint and injunction petition along with documents. So our plaint and the injunction petition made the major foundation for granting of, just say, because we don't have to produce any documents in most of the situations. Because they are saying that we are having 1200 bighas of land which do not have in our name. They are also saying that we are imposing HBS tax. There is no such document. They are saying that we are land grabbers. We do not have any such document. These are imaginary things they are saying. So for that we cannot go to police station and say that there is no case registered against me for land grabbing. So that is not my domain. So now on perusal of the plaint and injunction petitions along with documents, it is evident that by the injunction petition, the petitioner has prayed for restrictions to be imposed on the OPs from publishing, circulating, and disseminating any further defamatory concerning the petition along with other reliefs. Now, it is evident that the petitioner plaintiff is a chief minister and having high status in society. He has filed the instant petition for restraining the opposite parties from publishing so and so. 3 lines before the paragraph. Now, prior to decide the petition, I want to rely on observations of the Honorable Court, Apex Court regarding Article 19 of the Constitution vis-a-vis Article 21 of the Constitution. In Bloomberg's case, paragraph 9, in essence, the grant of pre-trial injunction against the publication of an article may have severe ramifications on the right of freedom of speech of the author and the public's right to know. An injunction, particularly ex parte, should not be granted without establishing that the content sought to be restricted is malicious or palpably false. This is where I am first giving my trust. Palpably false and malicious. Granting interim injunctions before the trial commences in a cavalier manner results in stifling of public debate. In other words, court should not grant ex parte injunctions except in exceptional cases. Ours will be an exceptional case. How? I'll make my submission a little bit later. In exceptional cases where the defense advanced by the respondents would undoubtedly fall at trial. In other cases, injunction against publication of material should be granted only after a full-fledged trial is conducted, or in exceptional cases after the respondent is given a chance to make their submission. In another case of express newspaper so-and-so, the Supreme Court, speaking through efficient justice, emphasized that though freedom of press is an inalienable right, but the same is not absolute and is subject to Article 19(2) of the uncontrolled right to speech leads to anarchism. The Supreme Court observed that I would only like to stress that the freedom of thought and expression and the freedom of press are not only valuable freedoms in themselves, but are basics to a democratic form of government, which proceeds on the theory that problem of the government can be solved by the free exchange of thoughts and by public discussion of various issues facing the nation. it is necessary to emphasize, and one must not forget, that the vital importance of freedom of speech and expression involve freedom to dissent to a free democracy like ours. Democracy relies on the freedom of the press. It is an inalienable right to everyone to comment freely upon any matter of public importance. This right is one of pillars of individual liberty, freedom of speech, which our court has always failing unguarded. I wish to add to the, however, precious and cherish the freedom of speech. It is under Article 19(1)(a). This freedom is not absolute and unlimited at all times and all circumstances, but is subject to restrictions contained in Article 19(2). That must be so because unrestricted freedom of speech and expression, which includes the freedom of the press and is wholly free from restraints, amounts to uncontrolled license, which would lead to disorder and anarchy. And it would be hazardous to ignore the vital importance of our social and national interest in public order and security of the state. In Umesh Kumar versus Andhra Pradesh, wherein the Honorable Supreme Court has held, allegation against any person is, if found to be false or made foregoing someone else's signature, may affect his reputation. Reputation is a sort of right to enjoy the good opinion of others, and it is in personal right and on enquiry to reputation is a personal injury. Thus, scandal and defamations are injurious to reputation. Reputation has been defined in dictionary as to have a good name, the credit, the honor or character which is derived from a favorable public opinion or esteem and character by report. Personal rights of a human being include the right of reputation. A good reputation is an element of personal security and is protected by the Constitution equally with the right to the enjoyment of life, liberty, and property. Therefore, it has been held to be necessary element to regard to right to life of a citizen under Article 21 of the Constitution. The International Covenant of Civil and Political Rights 1966 recognizes the right to have opinions and the right to freedom of expression under 19 is subject to right of reputation of others. Reputation is not only a salt of life, but also purest treasure and the most precious perfume. In Subramaniam Swami's case, the Honorable Supreme Court held that reputation cannot be allowed to be crucified at the altar of others' right to free speech. I'm skipping the next part. B. Another observation of the Honorable Court is also relevant in the present case, where it has been categorically held that protection of an individual right is imperative for social stability in body politic, and when harm is caused to an individual, the society as a whole is affected. Then paragraph 9, from the observations of the Supreme Court as discussed, is evident that freedom of expression in press and media is a part of Article 19(1) of the Constitution of India, where all the citizens have a right to express their views. However, the said right of expression is not absolute, but it is subject to reasonable restrictions imposed by the parliament or state in the interest of sovereignty and integrity, the security of the state, friendly relations with foreign states, public order, decency, morality, or in relation with contempt, defamation, or incitement to an offense. The said position is clear from the plain reading of Article 19(1) and 2 of the Constitution. It is evident from these fundamental principles that are to be satisfied for granting ad interim injunction, that is prima facie case, balance of convenience, and irreparable loss and injury. Prima facie case does not mean that the plaintiff should have a 100% case which will in all probability succeed in trial. Prima facie case means that the contention which the plaintiff is raising require consideration on merit and are not liable to be rejected summarily. So all the submissions I have made, that these are totally false, false and malicious, Lordship. I have said everything on oath, and I cannot produce any documents which are not in existence. So prima facie, the court has no other options to believe my case because I do not have 1200 bighas in my or my family's name of land. Then I am not a land grabber. I am not imposing any HPS tax. I am not part of the scams which they have named. I am not part of any kind of backstabbing of former private chief minister. These are all false allegations. And for that, I cannot produce any document. But I have to assert before the
Whether in the press conference, the report of which has been published in your newspaper, any basis or materials of making
No.
accusation
No.
was
Unlike Pawan Khera's thing. Pawan Khera had the materials, here did not have any materials. Not a single document they have produced.
okay.
Only oral. That's why I am very special in my earlier submission also. Orally, they made the statements. While in Pawan Khera's press conference, which is 1 month later, 5th of April, there were documents or materials, but those materials were found to be fake and forged, manufactured.
Okay.
In this case, there was not only verbal statements. Balance of convenience. To see balance of convenience, it is necessary to compare cases of parties, comparative mischief or inconvenience which is likely to sue. Withholding the injunction will be greater than which is likely to arrive at from granting it, than irreparable loss. There are many injuries incapable of being repaired, but a court of equity does not regard the same as irreparable. For example, cause which outrages the feeling or loss of things of sentimental value. On the other hand, there are injuries which in their nature may be repaired but still treated as irreparable. For example, a person who is inflicted or threatening someone as insolvent or unable to pay damages. Ordinarily, injury is irreparable when, without fair and reasonable address of court, it would be denial of justice. Very often, an injury is irreparable where it is continuous and repeated, or where it is remediable at law only by a multiplicity of suits. Sometimes the term irreparable damage refers to the difficulty of measuring the amount of damages inflicted. However, a mere difficulty in proving injury does not establish irreparable injury. The here important line is that very often an injury is irreparable where it is continuous and repeated, or where it is remediable at law only by multiplicity of suits. So suppose that news item was published on 5th of February. Every second day it was published. Then there will be multiplicity of suits. Then the damage will continue and the injury will also get accumulated. So this is a daily newspaper. Ohomia Proceeding or Proceeding Songbad. It's a daily newspaper. Every day if they publish it, then that will create continuous damages, continuous injury, and it will result multiplicity of suits because for every newspaper we have to file another title suit. Paragraph 11. In this case, from the materials on record, it is evident that the petitioner is the Chief Minister of Assam, having high status in the society, and his reputation has been dented before the society, and he has to suffer mentally due to the impugned defamatory publications by the OPs. The main line is here. Without any authentic document or subsistence proof, the newspaper did not say that Gaurav Gogoi, Bhupesh Baghel, and Jitendra Singh produced any documents or any materials or any evidence to substantiate their allegations. Both the newspaper did not have any such whisper also. So the Honorable Court, the other day, the other senior counsel was saying that without anything, this injunction has been filed. These very important 4 or 5 words, without any authentic documents or subsistence proof.
Okay.
So this is most crucial. We do not have to elaborate that. These few words, without any authentic document or substance, is sufficient. So this is where the exceptions comes. If some documents were produced, then the veracity of documents would lead to a case which cannot be considered as an exceptional case. But here it is the exceptional case. They are giving the verdict before the people of Assam or the entire nation just prior to the election that the Chief Minister is horribly corrupt. His family is corrupt. He is selling Assam for his family business. all these narratives, false narrative, people have given them the reply in election ballots, that is a different story. But in law also, Lordship, this is not permissible. Hence, after going through the documents, what are the documents? The pleadings, the plaint, both the plaints, as well as the statement of the CBI director, that Himanta Biswa Sarma was never questioned in Louis Berger case. Specific denial. So, hence, after going through the documents submitted by the petitioner plaintiff along with the plaint and in the light of necessary documents available before the court, at present, this court finds that a prima facie case is established in favor of the petitioner. What more is required, Lordship? Nothing more is required to establish it, because I am saying that I do not have that kind of property. I have never indulged in imposing HBS tax. I never indulged in any criminal scam. My wife is not having that kind of property, which they are alleging. And on oath, we are saying, if I say something wrong, I will have to face the music for that also. Perjury will be caused. If tomorrow they produce documents of 1200 bighas of land, imposition of this HBS tax, involvement of myself in the 3 scams which they have named, then immediately my plaint will be set aside, number 1, and also the Honorable Court can draw a proceedings against me for perjury, speaking false or untruth before the court. So, that a prima facie case is established in favor of him. The balance of convenience is also in his favor, because if there is no interference from the court at this stage, his reputation will be at stake and his position will be more inconvenient comparing to the defendants. So it will continue. I'll be put into more inconvenience by spreading of falsehood. Last, moreover, there is every possibility of causing inconvenience to the plaintiff and chances of suffering irreparable loss and injury by the plaintiff, which cannot be compensated by money. Yes, if they have continued this narrative till 9th of April, till the election date, at least the ruling party would have not got 102 seats, it would have gone a little bit less, because some people would have believed what they are saying is gospel truth. For them, whatever is printed in Proceedings, that is gospel truth. Without any basis. I have a press at my home, I can print anything. This printer can print anything. But it has to have some corroborative documents, contemporaneous records. So in the air, they are making wild allegations without any materials at all. And the court has believed us because we have stated everything on affidavit. Or not, nothing more I can do, because I cannot produce a document which will say that I cannot take a certificate from the circle officer that I do not own 1200 bighas of land. I cannot do that. That is not a normal course of functioning of the government offices and the government system. The ecosystem is not like that. If you are saying I have 1 rupee, you have to prove that I have 1 rupee. And they are not saying that I am having Benami properties. Rather, I am saying that I do not have any Benami property also. The challenge is open to them.
Okay.
So next line, Lordship. To sum up the aforesaid discussion, the court is of the considered opinion. So after considering all the principles, all the judgments, all the materials, they are saying that in a mechanical way, the Honorable Court has passed an interim order. No, there was detailed discussion. Nothing more can be added here. To sum up the aforesaid discussion, this court is of the considered opinion that if an order of ad interim injunction is not passed or as prayed for, it will defeat the justice and there is every possibility of creation of multiplicity of proceedings. And what is most surprising is that Gaurav Gogoi is not before this court, Jitendra Baghel is not before this court, and the other one? And Bhupesh Baghel is not before this court. And this newspaper agency or newspaper authority, they are just relaying what has been told in the press conference. So do they want to manufacture something more now? Gaurav Gogoi is happy with the injunction order. He is participating in the trial. So do the other two persons. How this newspaper is affected by this order? If nothing is said in a press conference, are they go to manufacture certain things to put it in the mouth of Gaurav Gogoi or the other two persons? Had Gaurav Gogoi came before, I would have understood that the court has restrained him from speaking against me. We are political rivals. Tomorrow, if any XYZ passes any comments against Dr. Himanta Biswa, they are free to report. Who is restraining them? Nobody is restraining them. That is why the Honorable Court is very specific in the.
Restraint was only in respect of news item.
Yes, that is
Right.
what I'm trying to tell before this Honorable Court. This is not a blanket order restraining new proceeding. They are doing everything they are liking. But so far as this part is concerned, that imposition of HPS tax, accusing scams, then traitor, all these things. And it has to be said by these three persons, Gaurav Gogoi, Baghel, and Jitendra Singh. So that has been restrained and they are happy with the order. This order has gagged them, not others. There are a lot of other political adversaries. So there is no infirmity in this, or may I read paragraph 13 now.
Yes.
An order of an interim prohibitory injunction is passed restraining the OPs, defendants from making, publishing, circulating, or disseminating any further defamatory statements or materials concerning the petitioner regarding the news item. Very specific. On 5/2 on the proceedings so and so, till appearance of the OP's defendants before the court. Once they appear, the court will apply his mind afresh. It is not an indefinite order. You go and appear, you come and place your documents. I am going to relook it, revisit the order. So, only in respect of one news item, this order was passed. No, both the news items, 1 and 2. So, in respect of that, the ad interim order was effective. And their grounds. If Lordship is pleased to look at their grounds. They themselves has said in ground number D, page 10.
Yes.
For that, the Honorable Civil Court Senior Division number 1, Kamrup, failed to appreciate that there is no prima facie finding of falsity in the impugned order, as it does not reflect the appellant inserted editorial commentary, reported inaccurately or attributed erroneous statements to political leaders. The publication in question constitutes reportage of a political press conference, a matter of the public interest. So he himself or they are saying that they are basically reporting whatever is uttered in the press conference. So he has not added any commentary, neither reported inaccurately nor attributed erroneous statements to political leaders. So if Gaurav Gogoi again holds a press conference saying something against, then he will get the opportunity to publish. So in my humble submission, this ground will not help him. For the simple reason, because only if there is a press conference or if there is a public statement by Gaurav Gogoi or the other two political persons, Lordship, then only he will get the opportunity to report. He cannot report something from the air. Only thing the court restrained on the same contents of the press conference and the newspaper items, the subject matter, you do not publish any further things till appearance. So, in my humble submission, the appellants cannot be aggrieved party at all. They are not aggrieved party. If they want to play politics, that is a different thing. But prima facie, in my humble submission, they are not aggrieved party. They cannot have a imaginary press conference to report something. These three gentlemen from the Congress party must have a press conference, then only he can report. The court has restrained that don't say anything on these points, on the subject matter of those two news items. That backstabbing a chief minister, imposing HBS tax, involvement in scams, and the other 3 points.
Okay.
So basically, Lordship, the ground number 1 and ground number 2, it is violation of Article 19(1). So Article 19(1) is not a blanket permission to say whatever one person would like to say or report or write. There are reasonable restrictions. Thousands of cases are there. And if you violate that, if you do not follow that restrictions, you have to face the consequences. Next is ground number 3C. For that the Honorable Civil Court failed to appreciate the well-established legal principles that a public figure, such as the defendant number 1, is necessarily subject to reasonable scrutiny and criticism by the press and public. This case is not a criticism by the press or a public. Totally misguided, misconceived ground. In this case, political adversaries are saying something against another political rival. There is no involvement of any public saying anything against Dr. Himanta Biswa or press saying something against him. No, whatever these 3 gentlemen in APCC headquarters in Gauhati, in Rajiv Bhavan, they said, those were reported. So it is not a case of any criticism or scrutiny by the press or public. We are not alleging that Proceeding is adding something. Whatever is said, they have reported. We very well accepted that. And now the case is, the foundation of the case is that. So in the paragraph D, they have said that they have not done any political commentary, editorial commentary, no incorrect reporting, no attribution of erroneous statement. These are not our case. These are absolutely not our case. The case is that some utterance was there by some political persons which are not based on material records, and therefore he considered the person who filed the title suit felt that this is a case of defamation. The allegation against the appellant is that without verification they have done it. That also is okay, fine. I hardly know that any of the news agencies nowadays do that. That is also acceptable. But this ad interim injunction order, how they are aggrieved, how they are affected. The persons, the main actors in the whole game, they are not unhappy, they are not aggrieved, they are not agitating. They are restrained from speaking. The reporter, who is just the medium, how can the medium be aggrieved? If he is not getting the raw materials, how the product will be marketed? The marketing agency, in my humble submission, I'm not using the word that political leaflet of a particular political party. I'll not use that. But the marketing agency cannot have a problem when the factory itself is closed. The factory is closed. The Gaurav Gogoi, Jitendra Singh and Bhagyal are stopped from saying all those statements, making those statements without any materials, unsupported or established documents. How the marketing agency is aggrieved. So their prayer does not contain whether it should be against them or against Gaurav Gogoi or against all. I do not know who is representing whom. But I hope that the journalists and the agencies are independent in nature, which is very a rare commodity nowadays. So ground number C and ground number D is totally irrelevant in our present context. Let us come to E. For that the learned civil judge failed to appreciate that the ad interim ex parte injunction prohibits the issuance of any further defamatory statements or materials concerning the respondent relating to the subject news. So who is making the statements? The three persons, 1, 2, and 3 in the original title suit. Yet its ambiguous and undefined scope creates substantial uncertainty regarding its application. So are they praying for some clarification of the order? If they are praying for some clarification, they should come with a specific prayer. So here that means they are happy with the order, but they need some clarification. That is why I am saying that prayer has to be specific. Lordship will not frame a issue without knowing their prayer. It is practically impossible. If Lordship frames an issue, tomorrow they will come to and they will go to the higher court and say that this was not our prayer, this was not our intention in the appeal. They themselves are confused. I'm not going again to the various fundamental mistakes they have made in the plaint, in the appeal, memorandum of appeal. But here they want further clarifications. If you look at the language, the lack of precise boundaries. Lordship will kindly see the next line. The lack of precise boundaries and the broad nature of this restriction raise legitimate concerns about arbitrary enforcement, potentials, chilling, subsequent reporting, public dialogue, clarification efforts, rebuttal statements. Accordingly, such restraint is inconsistent with the established constitutional principles that preclude vague and excessively broad orders. So what they want to basically mean is that they want clarifications. They want the boundaries to be demarcated. That means they are happy with the order. Their whole order should not go. Next, for that the order dated so and so entitled so has concluded a respondent role as chief minister and the alleged reputational harm warranted shifting of balance of convenience in his favor. But however, the reasoning is unsupported by any established jurisprudence on the subject matter, and moreover, it fails to recognize the heightened scrutiny applicable to public officials and overlooks the principle and damage constitute an adequate remedy in defamation matters. Legal precedent maintains that the damages should be presumed as the primary remedy rather than implementing prior restraint. So what they want to basically say, I could not fathom it, but anyway, Lordship, that the balance of convenience is well taken care of in the impugned judgment. If further reporting on the same subject matter is continued day in and day out, that will lead to multiplicity of litigations. That is a very minor aspect, the Honorable Trial Court, but the Honorable Court has said it will further damage the reputation. Every day he will be killed. His reputation will be tarnished every day. Every morning when proceeding will come, the reputational damage will be multiplied. Next is reputational damage unsubstantiated. G. The learned civil judge failed to appreciate that all material aspects, both the alleged damage to reputation and presumption regarding irreparable harm remain entirely unestablished due to the lack of supporting evidence whatsoever. What more is required? On oath, I have said that these are all false allegations, false accusations, and if it continues, it will further damage my reputation. By one publication, it has already tarnished my reputation, but if it is continuing, it will further aggravate the situation. And they want supporting evidence that my reputation is tarnished. If tomorrow they fail to produce a single document, which I am sure they cannot produce in nature unless they took the Khera's route. If Khera's route is not taken, then Lordship, they will not be able to produce any documents. then the title suit I will get success. But in the meantime, Assam election was over. At that point of time, I'm talking about the day when it was passed, that is 11th of February. Till that time, the election notification was not out. So by that time, the title suit will be finally disposed of. My reputation will be gone for a toss. Some of my voters will sway to the other political party who wants to get benefit through this misadventure by resorting to falsehood. But people of our country, they believe the newspaper still did to a high extent, and electorate will be misguided by creation of false narrative. So that damage, can it be compensated? Can that damage be returned to me? Can it be repaired? So they were given that opportunity, that injunction is granted, ad interim injunction granted till you appear, and fixing the date on 9th of March. So 9th of March was also the day which was prior to announcement of the election. If they could produce the documents, the veracity document will be tested later. But if they have come with an affidavit that yes, 1200 bigha is owned by Himanta Biswa Sarma and his family, and all other allegations, at least some semblance of evidence they produce, I am sure the Honorable Court would have reversed its order or discontinued the order, which they have not taken recourse to. That, what does it indicate? The court was very fair to them, because their target was basically 9th of April, the polling date. When they failed in this attempt, in this misadventure, they resorted to 5th April's press conference to Pawan Khera as well as Gaurav Gogoi and the other persons in Gauhati. As because it's a political case, I'm bringing all these political facts. Otherwise, I would not have taken all those names. So the reputational damage, who is an aspiring candidate for the upcoming election, who is an existing chief minister, his party is at stake. Everything is at stake before the election. What more is required? The overall circumstances is like that.
Okay.
So the reputation, if it is proved to be correct, that the allegations are correct, then his reputation will definitely go downfall. It will go to the declining way. But it is not correct. It was all wild allegations. Then who will take the responsibility of the damage which has already been caused and which has affected the election? Luckily, the people of Assam are very well educated. They are conscious, politically sensitive, and therefore the result of the election is before this honorable court. It did not affect the common people. So next is H. For that the learned civil court failed to consider the appellant's entitlement to raise various affirmative defenses, including truth, fair reporting, quantity. Who is stopping them? Who has restrained them? This ground they have taken, that they are entitled to raise various affirmative defenses, including truth. Yes, I welcome them. I challenge them. Prove those allegations. Who is restraining them? The learned trial court did not restrain them from producing any materials. 9th of March was fixed. Produce all the
Your
documents.
submission is that they could have appeared on 9th of March
Yes, Lordship.
and prayed for vacation
Absolutely.
only.
So nobody has restrained in that order also. Fair reporting. Who is stopped them from fair reporting? In fact, there are all unfair reporting going on. Qualified privileges. Let us take the qualified privileges. Public interest. Yes. To mislead the public interest is being resorted to. Public will believe, Lordship, that when newspaper like Proceedings, who has the highest circulation, I do not backtrack myself from saying that they are the largest selling newspaper, widely circulated newspaper in the state. So whatever they say, people believe. The belief is again subjective, but I am saying that people tend to believe. So when something is printed in black and white with bold headlines, the 8-column newspaper, news report, Lordship can see. First page, 2 big headlines, 8-column with bold letters, super bold letters. So I do not know, this is maybe an unholy nexus also. Other newspapers are not caring, otherwise we would have filed case against them also. Other people, other newspaper, both Khera's thing and this thing, it got the backbencher, not given importance because everybody in general knew that what they are saying is not based on facts. So public interest and fair comments. So alleging a person that you are indulged in corruption, you are selling Assam for your business and making comments, can that be a fair comments unless you have some materials to prove it? The issuance of an injunction absent a comprehensive evaluation of these defenses constitute an improper and premature adjudication of the substantive merit on the case. By the time they will produce these documents, Lordship, it will be too late in the day. If they can produce, we'll be more than happy. So this is my humble submission. So this is a fit case for dismissal in limine, and on merit also, they do not have a case. But if my colleagues will be here, I am taking it.
Any reply?
Yes,
Brief reply.
5 minutes.
Okay.
Lord, the first, I think, an objection has been raised that in the memo of appeal, my lord, that rule 43 R1 is not there. My lord, it's a mistake, but my lord, these are all curable defects, my lord. My lord, when arguments are coming from a law officer of the state, I don't think these are arguments which are normally forthcoming. These are all technical issues. Even non-joinder of party is not a fatal, my lord. After putting to notice, if somebody is not made a party, then it's a different thing. But my lord, there is a line of decision of the Supreme Court where Supreme Court has taken a contrary view. Now, my lord, it is in this context, I'll place that judgment, I brought it. Once my junior told me that this point has been urged. My lord, if a power exists under a statute, an authority exercises power without referring to that enabling provision and yet passes an order, then Supreme Court says, since source of power is traceable, therefore it will be presumed that this has been passed in exercise of that power. My lord, Purnomi Oil Mills is a famous case, my lord. I'll just hand over the copy. It is in the context of an authority passing an order without mentioning the relevant provisions.
So there is no bar for the court,
Yes.
but whether the
If your lordship
There is a-
I'll file an IA tomorrow, there's not an issue. But that cannot be a ground to non-suit me. I'm telling only that point. Well, I'm reading that passage, I'll hand over the copy. This is, my lord, citation is for my learned friends' information, 1986 Supplementary SCC 728. It is a very famous case, my lord, para 6. It is well settled principle of law that where the authority making an order has power conferred upon it by the statute to make an order made by it, and an order is made without indicating the provision under which it is made, the order would be deemed to have been made under provisions enabling the making of it. We accordingly hold that both these orders are section 10 of the Act. Therefore, I will respectfully submit, my lord, lordship will treat this appeal as order 43 rule 1R because there is a provision. And in fact, my lord, it's a typographical error, maybe, my lord, that order 43 rule is also mentioned. R1 is not there, 1R is not there. And I'm handing over the copy. Para 6, I have indicated also. So, my lord, I don't think that should detain us. Now, my lord, my learned friend was referring to each and every ground, then making submissions. Lord, my learned friend, while reading,
Have you appeared before the trial court?
no, I have not. Well, sorry, yes, we have appeared.
You,
We have, I'm sorry, Milord.
you have not filed
No,
written objection.
no,
You
no.
have sought time.
Because Milord, immediately we came because the matter was delayed for taking up because they took time on 3 occasions to file their affidavit. That's why the matter was delayed. Lordship may kindly check up the order sheet.
No, in this court, facts are known to me.
Yes.
What happened in the
No,
trial
in
court?
the trial court, my lord, we have not filed objection because we have approached your lordships for vacation of this order. Now, my
In
lord,
the trial court, what was your stand?
the trial court, we have not filed our written statement as yet.
You prayed for time.
Yes. Because we said that we have moved the Honorable High Court in respect of the ad interim order, and that matter is in court is in session of the matter.
No, but when the injunction was only till the next day,
Yes,
you could have prayed for the,
yes, I could have, but I can also come here.
yes,
There's
there
no
is no.
difficulty. I could have gone there, file an application seeking stay vacating that order, and I can also file an appeal under Order 43, Rule 100. So we have chosen this manner. Now, my lord, in this case, what is of utmost importance is my learned friend referred to ground F at page 11, and he said it is not fathomable to him. That is the word he used. Look, this is the fundamental thing in a law suit for damage. If somebody doesn't understand, who can help him, Miller? Kindly see. It says this reasoning is unsupported by any established jurisprudence of the subject matter. Moreover, it fails to recognize the heightened scrutiny applicable to public officials and overlooks the principle that damage constitutes an adequate remedy in defamation matters. It was not fathomable to him because this is the underlying principle in a damage suit. If a court feels that somebody's reputation has been impaired, then court can grant damages. Why injunction? People has got right to know. If tomorrow it turns out to be a correct information, then people will be deprived of the information, my lord. So this is the main fundamental rule. My lord, our case is very simple. What we have projected in our appeal is, in order to pass an order of injunction, the 3 golden principles has to be followed.
No, that you have already submitted.
Yes, that's what I'm reiterating, madam. Now, secondly, I say, when it comes to injuncting press, then there is an additional responsibility or requirement to be complied with, and has been laid down by the Supreme Court in Bloomberg's case. And the learned trial court, my lord, while referring to the Supreme Court judgment, first the learned trial court referred to the Bloomberg judgment. After reading Bloomberg judgment and after taking note of the caution which Supreme Court has indicated in Bloomberg, how this order could have been passed, my lord, since it is a pre-trial injunction, my lord. I am on that. And I have also said that the learned trial court, my lord, discussed the 3 principles. But when it comes to discussing the 3 principles with reference to the facts of the case, what the trial court did, my lord, trial court discussed only about prima facie case. About balance of convenience and irreparable loss, trial court has absolutely not mentioned anything. Therefore, it is an exercise of power which is highly irregular. It is irregular exercise of power. Therefore,
No, there was a submission by the other side.
Yes.
That in para 11,
Yes.
the court has reflected that the defamatory.
Let us read it once again, my lord. I have also read it.
He is emphasizing on the phrase
Yes.
without any authentic documents and substance.
No, my lord, what was it? They, my lord, kindly see, in this case, they rely upon one newspaper report to say the allegations are wrong. That newspaper report which says that in Sarda and Louis Berger, he was not added as an accused, but he was added as a witness. That was also a newspaper report. And these are also newspaper report. So to my lord, come out of the woods, you rely upon the newspaper report, and to say somebody is wrong, you are saying, condemning the newspaper report. Is it not a dichotomy, my lord? That's what, that was my argument is.
No, but one newspaper report is defamatory, other one is not. That is the distinction.
Who has come to the conclusion that it is defamatory? That is their allegation.
That is the allegation.
That allegation is to be decided, my lord.
No, and their contention is that defamatory statements were made without any basis, without production of any.
They said there is a requirement of verification. My lord, that is a matter to be decided at the time of trial. Now, as far I understand, the law is, my lord, before you injunct a.
And one more thing I want to
Yes,
clarification.
yes.
You were injuncted from publishing further news in respect of news item which has already been published on
Yeah.
5/2.
Ah.
So what was the injunction on you? You have already published the,
No, my lord. Supposing, my lord, I have got some more news on the same subject.
on the
matter.
same
Really,
subject. Okay, only to that extent.
Yes, I've been injuncted. On this subject matter, I have been injuncted. My lord, I am not on the merits of the case, my lord. All that I am trying to emphasize is to pass an order of injunction, and especially a pre-trial injunction, my lord, certain requirements are to be fulfilled. All that I am submitting, again, I am doing is, my lord, those requirements were not complied with. Please give me 1 minute time to refer to that Bloomberg's case for one paragraph, my lord.
They have emphasized on two words,
Yes.
that if the court comes to a finding that the news item which is sought to be injuncted is malicious and palpably false.
Where is that? There is none. There is no finding by the trial court. I've read it, my lord. I'll again read it if necessary. There is none. My lord will kindly have that Bloomberg's para 8, my lord. So, small paragraph.
Yes.
Bloomberg's case, my lord. 2025 1 SCC 4741. One at page 747. My lord, this is a caution.
Write a citation.
My lord, 2025 1 SCC 741. I have already placed it, my lord.
Yes.
My lord,
Para?
in para 8 at page 746. This is in addition to, my lord, the 3 golden principles. In essence,
Yes.
the grant of a free trial injunction against the publication of an article may have severe ramifications on the right to freedom of speech of author and public's right to know. An injunction, particularly ex parte, should not be granted without establishing that the content sought to be restricted is malicious or palpably
So your
false.
submission is court has not come to that finding.
Yes. Right?
Before.
Let us not put it too much, my lord. Establishing means prima facie. Now let us come to para 11.
So court should have made an observation.
Yes.
That there are materials.
Yes.
Okay.
Yes. My lord, one more thing I would like to point out, my lord. One second, my lord. Yes. My lord, Wanderer's case I have placed the other day, my lord. 1990 supplementary SCC 727, para 14, if your lordship would kindly come once, my lord. This was the first judgment on this point. This is a judgment, my lord, principally on the proposition that normally when an injunction is granted, it is an exercise of discretion. Therefore, in an intra-court appeal or an appeal, the appellate court should be slow in interfering with an order of injunction, because end of the day, it is only a discretionary power which has been exercised.
Yes.
But Supreme Court has pointed out, my lord, when the exercise of discretion would be wrong, para 14. If your lordships would kindly come to second sentence of para 14, in such appeals, the appellate court will not interfere with the exercise of discretion of the court of the first instance and substitute its own discretion. Now, this is important. Except where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where court had ignored the settled principles of law regulating grant or refusal of injunction. My humble submission, my lord, with all humility at my command, I'll submit. Here is an injunction order which the trial court has purportedly granted, my lord, ignoring the settled principles of law regulating grant of injunction as propounded by the Supreme Court in Bloomberg's case, which is latest in point of time, and more particularly it is apt because it also pertains to, my lord, how to injunct the press. This is my simple submission, my lord. Now, I'm just reading para 13 once again, my lord. wherefrom we can decipher that the learned court below, my lord, applied its mind to the relevant facts at page 106. Hence, an order of injunction is passed restraining OP defendant from making, publishing, circulating, disseminating any further defamatory statement or material concerning the petitioner. So where is the prima facie finding that this is malicious, this is palpably false? That's my humble submission.
Heard. Oh, yes.
Only one short reply, my lord, only with regard to my lord Bloomberg.
No, Bloomberg, I have already placed, I have not submitted anything new.
Yes.
No, my lord, I think I'm without meaning anything, my learned friend, my lord, there cannot be any reply, my lord. Invariably, I find, my lord, they will always come up with something. This Bloomberg judgment I have placed at the very beginning, you should have said,
Yes.
whatever, I have not said anything new.
There cannot be any reply of reply, but I am allowing you.
Why I am placing Bloomberg? It is not a new addition to the facts and circumstances. Bloomberg was relied upon by the learned trial court. Lordship may kindly, my lord, peruse paragraph 4 and 5. That much, only that much.
4 and 5
4
of
and 5, because Bloomberg is a fallout of my lord Morgan and Stanley. Prior to pronunciation of Bloomberg, my lord.
no. What you want to say?
My lord, paragraph 4 and 5. Here, my lord, how the ad interim ex parte injunctions would be granted by a trial court, in what circumstances, that has been called out in paragraph 4 and 5. Lordship will take note of paragraph 4 and 5. I will not consume the recess judicial time of this honorable court. Paragraph 4 and 5. And so far as, my lord, Wonder is concerned, prior to Wonder, way back in the year 1967, Honorable Apex Court has, my lord, pronounced similar dictum with regard to the parameters and the circumference under which, my lord, an appellate court would, my lord, decide on an issue pertaining to ad interim ex parte injunction. That much only. And that decision, my lord, I have already given a list of books, my lord, that is AIR 1967 SC 249. AIR 1967 SC 249. Uttar Pradesh Cooperative Federation, paragraph 8, my lord. AIR 1967 SC 249, paragraph 8. That much only, my lord.
I'll pass orders in chambers. I'll dispose it of today itself.
And so deeply obliged.
Item number 34.
Item number 4. Yes.
If I may, my lord, I'm newly engaged by the respondents, my lord. As such, my lord, the Wakalatnama has not yet been filed. My lord, I pray for some time, my lord, 1 week's time.
Whether appeal has been admitted.
Oh, my lord. This is a testamentary application, my lord, wherein I have prayed for removal of the executor. As per section 301 of the succession. Already they have filed their affidavit.
Which order you are impugning?
No, my lord, I am not impugning anyone. I am one of the beneficiary out of the will.
Okay.
So I have prayed for removal of the executor, my lord. Because, my lord, certain things, my lord, deeds he is, my lord, doing against the, my lord, objective of the will. And more importantly, my lord, the probate was not filed. We have filed this application, my lord, just before the limitation period, my lord, was exhausted. Prior to that, we have filed this application, my lord.
301. Heard Mr. R. Chakravarti, learned counsel for the applicant. Also heard Mr.
G. Imtiaz.
G. Imtiaz, learned counsel for whom you are
My lord, for all the respondents.
learned counsel for the respondents who submits that he has been newly engaged by the respondents to appear in this case, and he would be filing his vakalatnama shortly
Yes.
and seeks an adjournment of 1 week. The prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Date will fix. I've got some others here. Before that.
8th of June.
Keep your blade.
Timing item 5.
Succession Act, the Oxford Indian Succession Act. Yes, Mr. Ghosh.
Lordship, beg your lordship. This is a minor appeal filed against the my lord judgment, my lord, page 117, granting the provisions. Time it has come. My lord, we have challenged this principally on the ground, if your lordship, I speak my lord, straightway to the grounds, my lord.
Heard Mr. B.J. Ghosh, learned counsel for the appellant. This appeal under Section 299 of Indian Succession Act 1925 has been filed by the appellant impugning the judgment dated 6/2/2026 passed in title suit within bracket probate case number 2/2024 in by the Court of Learned District Judge Lakhimpur, whereby the application filed by the present respondent for grant of probate was allowed. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Issue notice to the respondents and let the records of title suit probate case number 2/2024 be called for from the trial court. The appellant shall take steps for issuance of notice upon the respondents, upon the sole respondent by speed post as well as the usual mode within 7 days from the date of this order, returnable on 15th July.
We have a filing petition on the order 41 rule 5, my lord. Two of these judgment till let them come
We are issuing notice.
on this state petition also. Order 41 rule 5 petition is there.
We are issuing notice in the interlocutory application.
Till then, my lord.
No. Let them appear.
Bless.
Wait, please, your lordship. Lordship, I filed this FAO, lordship. My ad interim injunction was rejected by the trial court, lordship.
When is the next date fixed?
Lordship, it is on 22nd of May, lordship. But the thing is that what has happened, lordship, is that this is a suit between the brother, but both the brothers, lordship. I am the elder brother, lordship, and I'm working as a colonel in the Indian Army, lordship. What has happened, lordship? My father is suffering from dementia from last 3-4 years. So whatever the documents with my father, whatever rent, we had some tenants. All these tenants we used to pay rent in a joint account between me, the respondent number 1,
and the pro forma defendant number 6, who is my father. Now,
Who is respondent number 1?
my brother, Lordship.
Okay.
Now, Lordship, what is happening? I have some fixed deposits which I have deposited in the name of my father. And what he has been doing, he has been digitalizing the mobile number of my father, along with all the documents which my father has. He has been using my father's signature and has been withdrawing all the money from the joint account, from the investments which I have made, and he has been transferring it to his own independent account and also the account of the wife. Now, Lordship, I am serving in the army and I have to travel places to places. I cannot stay in Gauhati. So using that as a lever, he has been doing this option. Now, my thing is that I do not need, I'm on a very limited ground. All I want as of now is the rent which has been paid by the tenants has to be deposited by the respondent number 1 in the joint account. Because this is what has been happening. Lordship, kindly turn to page number 29, Lordship, for a moment. 28, Lordship. The land may be in the name of my father, but I have independent electrical connection. Lordship.
Respondent number 1 is your brother.
My brother. Now, Lordship, page number 29 may be seen once, Lordship. So this is a joint account. Hiralal Das. Page number 29.
Page number?
29, Lordship.
Yes. Schedule C.
Yes, Mr. Hiralal Das. He is my father, Lordship. And joint account holder Akshay Das, that is me, and Ashim Kumar Das, the respondent number 1. Now, the thickness of thing was that the rents which were collected by me or my brother were deposited in the joint account. Now, what has happened after me staying elsewhere and after my father is suffering from dementia, those rents, he has been collecting it and he has been depositing in the name of his wife. So now this is a complete ouster of me from the entire relationship, Lordship. Now, once rents are paid to somebody else, I am no longer the landlord. Neither I have possession of the land. Now, I am not asking any relief against my husband, against my father. Now, the land is my father's. All I want, the deposit.
Land is your father's land.
Yes. The only thing I want is, Lordship, he should not misappropriate my father's property, since he's right now he's not in a stable mind. It happens always like that he roams around the places, he goes elsewhere, he cannot find a way to his home. So he is on the mercy of my brother. He doesn't even take care of him, and he is using all the property, all the means he has in the house to all in his name, Lordship. My father cannot say anything. If today he puts a signature of my father, that is not a concern of my father. And that is the exact reason why, Lordship, I have filed an application under Order 32, Rule 15 before the trial court.
Is it?
The Lordship, appointment of guardian, Lordship. My case is that, Lordship, my father is not in a mental state.
Where is the impugn order?
Lordship, if Lordship is perusing the FAO, then the last page, Lordship, page number 55. Petitioner plaintiff is represented. The instant miscase is registered on the basis of an application filed by the petitioner under Order 39, Rule 1 and 2, read with Section 151 of the.
It is depositing of monthly rent only.
Not with regard to tenants. He anyways collecting from the tenant. All I want him not to deposit in his wife's account, deposit it in the account of my father. That's all.
No, then where is the urgency? It can be. It is already fixed on 21.
Lordship, Lordship.
Where is your interim injunction petition?
Lordship would find that I have not filed it today. I have filed it way back in the month of March itself. And then, Lordship, it was rejected. Then I came before this court, Lordship. Now, Lordship would find my injunction petition if my lord takes up the IA.
in the Lordship, I have filed for injunction. Page number 75 is a miscase. Lordship, I'm sorry, Lordship, page number 29 that I was referring to is in the miscase only. If Lordship may kindly see the page number 29 once. Page number 75 is my injunction petition. And page number 29 may be seen.
No, where is the urgency? Statement regarding urgency.
In the injunction petition, Lordship.
Yes, in the injunction.
But
Apart from para 29.
that is the statement I have made. With regard to that page number from page number 22 onwards, Lordship. In page number 87 onwards.
Which para you have mentioned that narrated the facts which will indicate the urgency?
Lordship 22 onwards. Para number 22, page number 87.
Read it.
The petitioner states that under the prevailing circumstances, it is imperative that the suit length in Schedule A, the RCC structure described in Schedule B, and the pro forma defendant number 6 investments, including fixed deposits and mutual funds and others, be preserved in their current state to protect the interests of the petitioner with his incapacitated father. Accordingly, the petitioner has filed before this Honorable Court his instant application under Order 39 Rule 1 and 2 of the CPC for temporary injunction restraining the respondent number 1 and 2 from alienating the suit property or execution of any will, gifted, lease, or sale deed by fraudulent exploitation of the condition of the respondent number 6. Furthermore, it is prayed that the respondent number 1 and 2 be restrained from liquidating any financial assets or manipulating the rental income through the manipulation of bank credentials. In absence of such equitable relief, the respondent number 1 and 2 will succeed in siphoning these liquidated assets and creating third-party rights in the suit land, causing irreparable loss and injury to the petitioner and mentally incapacitated.
No.
No, Lordship,
The facts indicating that they are going to do these things
yes,
immediately.
Lordship, because Lordship, that is page number 86. What has happened? The petitioner states that most recently on 1/1/2026, the pro forma defendant number 6 went missing from the morning for his dementia and he could not remember his way back home. The respondent number 6 was taken home by a family member and he saw that the pro forma defendant number 6 was walking in the street aimlessly near Chabipul area in Gauhati. The pro forma defendant number 6 was also in fear as to how the respondent number 1 and 2 shall abuse and hit him for forgetting his way back home. The respondent number 1 and 2 failure to provide a secure environment along with the fear they are still instilled in the respondent number pro forma respondent number 6 and has significantly infringed upon his right to dignity and autonomy, which must be upheld. Now, Lordship, what the condition is that it is not that today he went and tomorrow he might not. His condition is very unstable and I am not allowed access to my father. Now, under such circumstances, I have filed an application under Order 32 Rule 15 of the CPC, Lordship, along with this case. Now, in that case also notice is very issued. Now, if something happens in the meanwhile, because this is continuously happening, any dementia patient, Lordship may kindly see I have enclosed the medical documents, Lordship. Every day his condition is deteriorating and I'm not asking anything against him and against him. He is my father only. All I am saying that my father's money should be father's money. That is all I want. Lordship may see, since I'm in an army, I can only rely on army documents, Lordship, the army hospital, Lordship. It starts from page number 49, the typed copies. We in army do not get any handwritten, we do not get any certificate from the doctor. Base doctors writes it in the diary. So these are the extract copies of the diaries. The exact copies are in page number 55 onwards. And my father is not being treated in a civilian hospital.
No, what interim relief you are seeking?
Or is that the rents or anything should be deposited in the
When the rent is deposited, when you get rent from the tenants.
Lordship, initially Lordship, if Lordship will see page number 29, it was deposited every month. The next month, it was deposited information to me in the joint account.
When?
Every month, the first week of every month. Lordship. Now, that has not been done. Now, what happened? He collects the rent and either through UPI or by cash. And then he deposited it to his wife's account, to his account.
Now what do you want? The money which has already been deposited in.
That is a matter of trial. What I basically want is that whatever the rent is, you kindly deposit in
From the next month onward.
the joint account. That's it. I need nothing else.
Then there is no urgency.
So, Lordship may kindly see. And also with regard to Lordship, this is one aspect of the matter.
Yes.
That is, urgency is one aspect, Lordship. The another aspect is that he has access to the signatures of my father. Today, if he
No, but
will
that is only your apprehension that he will do so. But on what basis? Only once he.
My humble submission is only with regard to limited. Otherwise, I have a multifaceted prayer, Lordship. If Lordship would see, I have a multifaceted prayer. But as on date, I'm not asking for that, Lordship.
Your prayer is not rejected by the trial court. Only notices.
Lordship,
And trial court held that, considering the nature of the case.
When an ad interim injunction application for ad interim injunction is there, if a notice is issued, that is amount to rejection. That's why I filed an appeal, Lordship.
But you.
That is the law, Lordship. I'm aggrieved by issuance of notice only. I had urgency, that's why I filed this case, because this has been otherwise, Lordship won't.
Then you have failed to if you fail to justify that you have a case to dispense with the notice, then this appeal is liable to be dismissed. If you fail today, it is liable to be dismissed today. If your limited prayer is that for not granting ex parte an interim injunction, you have approached this court. And you have to satisfy that you have a case for waiving the notice in the trial court.
Understood, Lordship, under Order 39, Rule 3, Lordship.
Yes. That aspect was considered by the trial court.
So, Lordship, that aspect, Lordship, it is not. Lordship, kindly read the judgment once, the order once. It has not been specifically mentioned. Perused the petition, heard the learned counsel, and also gone through the annex documents. After considering the nature of dispute and facts, I am of the view that it would not be just and proper only. There is nothing about urgency to pass an ad interim injunction without hearing the other side.
No, therefore, I am asking, where is the urgency shown in your injunction petition?
Kindly give me some time, I will satisfy.
Okay.
After tomorrow.
Heard Mr. P. Deka, learned counsel for the appellant, who prays for some time for making submissions to satisfy this court that he has a case for grant of ex parte ad interim injunction
Grounds of urgency.
on the ground of urgency. The prayer is allowed. Let this matter be listed on Monday. On Friday.
Right.
15th. 15th May.
August, item number 13.
May I please, the Lordship? Lordship, as per office note dated 11/5/2026, Lordship, no ID card or unsub notice has been received yet, Lordship. But Lordship, the notice has been confirmed as delivered to respondent number 1 on 17/3/2026 as per postal journal, Lordship.
How many respondents are there?
Respondent three, Lordship, two stack of Lordship, three already appeared and one notice served.
Miss, what is your name?
Are they appearing on behalf of AJ Ghosh?
Are they? Learned counsel appearing on behalf of Mr. A.J. Ghosh. None has appeared for the respondent number. Who is represented?
Number three, Oriental Insurance.
None has appeared for respondent number 3. On perusal of the office note dated 11/5/2026, it appears that the postal track consignment report of notice issued to respondent number 1 shows that the notice has been delivered to the addressee. Hence, the said notice is held to be duly served on the respondent number 1. This IA is for
Delay, Lordship. Condition of delay.
Mr. A.J. Saka is not there. We are giving a small, we'll take it up in the next week. Let this matter be listed again in orders column in the next week on a date to be fixed by registry.
Please, Lordship.
Item 14.
Yeah.
IA number 1307 of 2024 may be taken.
13
1307
1307.
of 2024.
This is for what purpose?
My lord, here in this case, my lord, my contention was that I have been given 1,85,808 rupees less compensation towards my land acquisition. But after going through this affidavit in opposition, my lord, and also it was heard by your lordship once, it was seen that it is not deducted from my compensation. It is the additional amount given to the deputy commissioner. So, my lord, this miscase may be closed. This IA may be closed, madam. They file affidavit in opposition also, madam.
In this IA.
In this IA, madam, 1307. So, my lord, there is nothing to be adjudicated, my lord. It will be closed.
Heard Mr. M.A. Sheikh, learned counsel for the applicant. Also heard Mr. T.R. Gogoi, learned counsel for the. You are appearing for?
Respondent number 1.
Respondent number 1, as well as Mr. K. Gogoi, learned central government counsel appearing for respondent number 2. Learned counsel for who has filed affidavit?
Respondent number 1 has filed.
Learned counsel for the applicant has submitted that after going through the contention of the affidavit in opposition filed by the respondent number 1, the present applicant is present applicant is not inclined to press this interlocutory application as he has already received his share of the compensation awarded to him, and it is not less as has been stated in the instant interlocutory application. This interlocutory application is accordingly closed. And in the LA,
But now your lordship would be pleased to take this IA number 1842. But your lordship, before going to that, your lordship will take this alia appeal. Alia appeal. In alia appeal, my lord, I am referring to order dated 8/6/2020. Alia appeal.
86
8/6/2022.
yes.
So, my lord, here your lordship directed me to amend the memorandum of appeal. Because, my lord,
8/6/2022.
yes, my lord. 8/6/2022.
22.
22. 22.
No direction. You prayed for filing amended appeal. You prayed for some time for.
My lord, actually point raised, my lord, that I have filed this appeal under the provision of 1864 Act, this Land Acquisition Act.
Yes.
Your lordship pointed out to me that there is 2020, this Fair Compensation Act is there. So your appeal is not over. So I seek for time. Thereafter, what happened, my lord? Ultimately, on 5/8/2022, that is why, my lord, I filed this IA for amendment of the memorandum of appeal, IA number 1842 of 2022. Now your lordship would be pleased to see order dated 5/8/22. Five eight 22.
There is no 5/8/22. 86. Next order is 2/11/2022.
Well, appeal is admitted, my lord, by a certain order. Maybe I may be wrong.
Yes, 5/8 in the
5/8.
in the interlocutory application. Yes.
Interlocutory appeal. My lord, here 5/8/22 appeal is admitted.
Where?
My lord, here it is 5/8/22 amendment not necessary. As amendment applies only pleading or amend of pleading. In the present case, memo of appeal is not pleading. I may be wrong. I have recorded that.
Which order you are referring?
5/8/2022, my lord.
Pass in.
Pass in IA, my lord. 1842.
Yes, read. Which para you are reading?
Amendment is not necessary.
Where are you reading?
5/8/2022.
Which paragraph? There are many paragraphs.
No, my lord, order.
In the order, there are many paragraphs. Which para you are referring?
But I have not gone through the detailed order, my lord.
You don't have the order with you.
No, my lord.
Okay. No, appeal is not admitted. Appeal is listed for admission hearing. It is yet to be admitted.
My lord, in that case, my lord, as amendment is not necessary, in that case, your loss.
No, the observation is the amendment may not be necessary. That question shall be determined during the final hearing of the appeal.
So, my lord, in that case, appeal is to be admitted. If that order is taken on record, my lord, that final hearing, in that case, appeal is to be admitted. So in that case, my lord, may I pray before your lordship that appeal may be admitted, let it be go for hearing. And this miscase may be disposed of.
No, in this case,
Miscase 1842 of 2000.
there is an order that this IA shall be considered at the time of final hearing of the appeal. So it has to be kept pending.
Kept pending. In that case, my lord, if it is, as it is observed by your lordship, that this petition may be considered at the time of final hearing. In that case, appeal is to be admitted. That is my submission, my lord.
Yes, Mr. Gogoyan.
We have not served a copy yet, lordship.
Of
IA, what to say, 1842, also 2022, lordship.
in IA number 1842, in the year 2022, order has been passed that the said IA is kept in abeyance to be considered along with the final hearing of the appeal. The IA was for amendment of the memo of appeal.
Let it be final. Let it be considered in final hearing also.
How it can be in final hearing? Whether appeal is to be filed under
What's your
30, Act of 13 or Act of 1894.
1894.
He has sought for an appeal is admitted on 211. By a different bench. Order dated 2/11/2022 in we'll take it up as the next item. You both of you go through the order sheets. I have flag mark it. Itu record to diyo. He record to tab diyo.
Item 15.
May I please, your lordship, I am for the appellant here. As per judgment of the Honorable Appeals Court, I have to file an affidavit, declaration that my earnings and leasing. Otherwise, this case it already been both party has admitted that it is left for a permanent alimony, only question was left. The reason my affidavit is required, I'll be filing within 1 week. That affidavit, my landlord friend has already filed. I have to also file my declaration declaring my assets.
This appeal is for what?
That
Against the decree of divorce.
Divorce.
Divorce. Otherwise, she also agreed.
Agreed to what?
Agreed for divorce was subject to some permanent.
We have verified the record loss. On 2/11/22, it was admitted loss. After admitting, they have sought for amendment loss. On 8/6, they have sought for amendment loss. Before that, lordship said admit the matter on 2/11/22 lordship. And
So appeal has already been admitted.
Alicia also called lordship, it is taken the record also.
So
Lordship may fix the matter for hearing.
final hearing.
Lordship.
Heard Mr. M. A. Sheikh, learned counsel for the petition, learned counsel for the appellant. Also heard Mr. K. Gogoi, learned central government counsel.
Only one thing, what my learned friend submitted, that we asked for amendment after the appeal is admitted. Possibly, my lord, it is not proper, my lord.
8-6 order.
On record, my lord, 8/6/2022, we filed the amendment petition. 26/2022.
8-6 order closures.
Your lordship would be pleased to see my affidavit
6 order.
in IS Civil 1842 of 2022. It is before admission of.
Also,
6 order.
heard Mr. T. R. Gogoi, learned counsel for respondent number 1. And Mr. K. Gogoi is appearing for
2 lords.
respondent number 2. It appears that this by order dated 2/11/2022, this appeal was admitted. It also appears that in IA civil number 81842/2022 by order dated 5/8/2022, it was observed by this court that the interlocutory application wherein an amendment was sought for in the memo of appeal was directed to be considered at the time of final hearing of the appeal. Stop. Since the records of the trial court has already been received and this matter is ready for final hearing, let this land acquisition appeal be listed for final hearing on
The date may fix because my.
13th of August.
13th of August.
13th of
A
August.
bit earlier, my lord, because the petitioner, my lord, before your lordship, is 93 years old. Is on the verge of death. 93 years old. So, my lord, it may be a bit earlier. Not in our.
Why are you saying he's on the verge of death?
That's we also thinking
I'm
lords.
3 years, my lord.
We also thinking lords.
That is, he repeatedly requesting me, my lord, because 93 years is very considerable age, my lord. He repeatedly is requesting that my case is possible decided by the Honorable High Court during my lifetime.
14 July.
Item number 16.
Well, as per office note dated 23/4/2026. Trial court record has already been received here. So matter may be fixed for final hearing.
Trial court.
Office
Okay.
note 23.
Heard Mr. A. Chaudhary, learned counsel for the appellant. Also heard Mr. T. R. Gogoi, learned government counsel, appearing for respondent number 1, as well as Mr. B. Pathak, learned counsel for respondent number 2. It appears that the trial court records have been received and this matter is ready for hearing. Hence, let this appeal be listed for hearing on 13th of August.
Lovely.
Item 17.
May it please your lordship, as per the last order, review petition number 31 of 2025, we have filed an affidavit in compliance of service of notice upon the respondent number 2. So that's the move.
What is your name?
Jay Hawk.
Heard Mr. J. Hawk, learned counsel for the review petitioner, who submits that. Where is the affidavit?
It could be on the records.
It shows that no affidavit has been filed. When have you filed? Who submits that the the petitioner has filed affidavit in compliance of service of notice on respondent number 2 through the mode. Stop. However, the office note dated 12/3/2026 shows that no such affidavit has been filed. The registry to verify and place the affidavit filed by the petitioner on record, along with this record with an appropriate office note. Let this matter be listed again
19 June.
on 19 June.
Item 18.
May I please, your Lordship? Lordship, we have taken steps upon the respondent number 5, Lordship, on 12/5/2026.
Heard, Miss, what is your name?
S. Nath, Lordship.
S. Nath, learned counsel for the appellant. Also heard Mr.
K.U. Ahmed,
K.U. Ahmed, learned counsel for
respondent number 1 to 4.
1 to 4. Though learned counsel for respondent number 5 submits that though the learned counsel for the appellant has submitted that the appellant has taken steps for issuance of notice upon respondent number 5 in pursuant to the directions of this court, however, the office note dated 8/5/2026 shows that no such steps has yet been taken. When have you taken steps?
Lordship, on 12/5/2026.
Stop. Learned counsel for the appellant submits that the appellant has taken steps on 12/5/2025. Registry to verify and list this matter again after 2 weeks with an appropriate office note. Please take on.
Item 19.
May please be Lord. Lordship, this appeal was settled in Lokadar Lordship for 30 lakhs Lordship, and the 50% amount has already been withdrawn Lordship, and the balance amount of rupees 16,46,988 has been deposited with the registry of this court. And this settlement Lordship in para number,
Now, why it is listed?
it is listed for that filing of affidavit by the mother-in-law that she has received 50,000 earlier, and now 5 lakhs she has to receive Lordship. And order dated 14/3/26 may kindly be verified Lordship. Para number
Item number 19.
19. Para number 7 Lordship. In that course, we have submitted affidavit before the registry.
No, but this appeal has already been disposed of. Why it is listed?
For filing of affidavit with the mother-in-law, she has received the amount 50,000, another 5 lakhs she will be receiving. For clarification by the registry also. An order dated 14/3/26, para number 7 may kindly perused also.
Having regard to the said settled amount is agreed, subject to filing an affidavit before the registry of this court. The respondent number 4 stating agreement. No, what this court has to do? Court has already. Okay, okay.
We have filed the affidavit by the mother-in-law.
So how much you have received?
Earlier I received lordship that 13 lakhs 53,102 lordship.
50,000.
Earlier I received 50,000 and again another 5,000 lakhs I am received lordship, mother-in-law.
No, I am asking how much you receive. You have received 50,000.
50,000.
And
My mother-in-law will be receiving 5 lakhs and the remaining amount from the 16 lakhs, the
out of the 16 lakh 46,988, you will get 5 lakhs.
yes, Lord.
And remaining?
Remaining will be respondent number 1, lordship, 9 money payable, lordship. That clarification is to be clarified.
What was the settlement? Who will get the remaining amount out of the 16 lakh?
Respondent number 1 will get the
Who is respondent number 1?
wife of the deceased person. And 4 is the mother of the deceased.
No, where is that direction that respondent number 1 will get?
Number 6 also there, agreed respondent number 1, the 30 lakhs others.
There were 4 claimants.
Yes, Lord.
So what happened to respondent number 2 and 3?
They are the daughters of the respondent number 1, Lord. Minor daughters. 50% also received by the respondent number 1, Lord.
And daughters will not get anything.
Minor daughters, they are maintained by the respondent number 1, Lord.
What was the direction as regards them?
All that 50% payment, respondent 1 was paid, and out of that, he has paid 50,000 to the respondent number 4, Lord.
Regarding FDs? FD? Whether there was any direction?
No, Lord.
Have you seen the judgment of the tribunal.
Tribunal order is there, Lordship.
Whether-
51 lakh each. It is there in the para number 55, Lordship.
Let that be deposited
Okay,
to
Lordship. That can be.
item number 19. Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. A. R. Agarwala, learned counsel for the respondent. Respondent number 1 to 4 /
Elements.
claimants. It appears that this matter, this appeal was disposed of in the Lok Adalat, National Lok Adalat, which was held on 14/3/2026. And the this appeal was amicably settled between both the parties at an agreed amount of rupees 30 lakhs. Stop. While disposing of this case, it was directed by the Lok Adalat in its order dated 14/3/2026 that respondent number 4, who is the mother of the deceased, will get 5 lakhs
In addition to 50,000.
in addition to rupees 50,000, which has already been paid to her. What happened to earlier 50% amount?
That is received by the respondent number 1, wife of the deceased.
It is,
Out of that, 5 lakhs, 50,000 has been paid to the.
how much was 15 lakhs was deposited?
No, 13 lakhs, 53,000, 12 rupees.
It is also submitted that the out of the settled amount, an amount of rupees 13,53,012 has already been deposited by the respondent, by the appellant insurance company, and same has been disbursed to respondent number 1, out of which a sum of rupees 50,000 was paid to the respondent number 4. The Lok Adalat also directed the respondent number 4 to file an affidavit before this court to indicate as to whether she is agreeable to the settlement arrived at in the Lok Adalat. Accordingly, the respondent number 4 has filed her affidavit indicating her consent to the settlement arrived at in the Lok Adalat dated 14/3/2026. Stop. You have deposited 60. This.
Yes.
The insurance company have you deposited?
Yes.
Insurance company has already deposited the remaining amount of rupees 16,46,988.
That is matter of record also.
Stop. As was directed by this court, as was directed by the Lok Adalat, the registry shall disburse. Out of this amount, 5 lakh will go to you.
Yes,
That's number four.
this one for.
Out of this amount, registry shall disburse an amount of rupees 5 lakhs out of the aforesaid amount to the respondent number 4 in terms of directions passed in law, in terms of the amicable settlement arrived at in the Lok Adalat. How much will go to the share of respondent number 1?
This one, one lordship. The remaining one should go, but some
Oh.
amounts can be kept as fixed for this one, 2 and 3 lordship.
2 lakh each,
As per original 5 lakhs.
5 lakhs each.
So earlier
There are
50%.
56 at the
2,50,000, lordship, then earlier 50%
Para?
has been done.
there are 56 of the judgment.
56. 5 lakhs each is there.
Then deposit 5 lakh each.
No, lordship, then earlier 50% has been done. Now we are coming to the 50% only. So 2
Now,
lakh.
whether 50% was deposited in FD.
No, lordship.
Now,
That is received by the respondent one. lordship.
now it has to go to
So the even lordship, we have to maintain the minus.
out of the, how old are the,
They are still going student lordship.
as was directed by the Motor Accident Claims Tribunal, out of the remaining amount, rupees 5 lakh each shall be deposited by the respondent number 1 in the name of respondent number 2 and 3 respectively in a nationalized bank in fixed deposit till they attain the age of maturity. The remaining amount shall may be disbursed, may be taken by respondent number 1. With above observation, the registry to comply with the above directions.
This is a condonation petition of 80, a delay of 82 days, Your Lordship.
To dispose of case, already disposed. Yes.
82 days delay, Your Lordship. Your Lordship, the judgment and award was passed on 11/3/25, Your Lordship. And appellant came to know about the judgment in the second week of June 25, Your Lordship. And accordingly, he applied for the certified copy, Your Lordship. After receipt of the certified copy, the applicant came to know that that cost has been imposed upon him. And accordingly, he filed a petition for review of the judgment and order. And accordingly, on 18/8/2025, the applicant was released from the liability to pay the cost, Your Lordship. And accordingly, Your Lordship, there has been a delay in filing of this MSC.
How much delay?
82 days, Your Lordship.
When you filed the review application?
Your Lordship, on 19/7/2025, Your Lordship.
And when it was disposed of?
On 18/8/25, Your Lordship. And that also, Your Lordship, on the date, Your Lordship, the year was wrongly mentioned as 24, Your Lordship. That was also corrected later on, Your Lordship. It was corrected 18/8/25, Your Lordship. I have annexed
Yes, are you objecting? No objection. Heard Miss S. Nazneen, learned counsel for the applicant. Also heard Mr. J. Kolita, learned counsel appearing for respondent number 3. Miss R. D. Majumdar, learned counsel appearing for respondent number 5. And Miss P. Seal, appearing for respondent number 4. Who is for 1 and 2?
The causes, your lordship.
No,
the-
none.
Islam.
None has appeared for respondent number 1 and 2. Though names of the engaged counsel for respondent number 1 and 2 have been reflected in the cause list. This interlocutory application has been filed by the applicant Shri Dulal Bora, praying for condonation of delay of 82 days in preferring the connected MAC appeal, whereby connected MAC appeals stop. The learned counsel for the applicant has submitted that the applicant has mentioned the reasons for delay in paragraph number
8, your lordship. 7, 8, 9, your lordship.
7, 8, 9, 10, and 11. 11 and 12. Stop. Considering the grounds stated in the instant interlocutory application, the learned counsel for the respondents have not opposed the prayer for condonation of delay. I have gone through the grounds stated in the instant application. Considering the same to be sufficient cause which prevented the present applicant from preferring the connected appeal within the prescribed period of limitation, comma, the delay of 82 days in preferring the connected appeal is hereby condoned, and this interlocutory application is hereby allowed. Registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it. The names of learned counsel for the respondents, as indicated herein before, shall be reflected in the cause list henceforth.
Memo of appeal.
The applicant is directed to furnish requisite copies of memo of appeal along with annexures to the learned counsel for the respondents.
Then 23.
My page, your lordship. My lord, this is an application for completion of delay of 48 days, lordship. Regarding service, lordship may kindly peruse the office note dated 4/11/25, lordship. Respond number 4 already appeared, lordship, and respond number 1, answer notice receipt, and the respond number regarding 3 and 5, lordship. No ID card has been received.
So 1, 3, and 5, what way? You have to take fresh steps.
1.
1, 3, and 5.
My narrative single counsel is appearing.
You are appearing for
1 and 2.
1 and 2. Respondent number 1 and 2.
and 3 and 5.
3 is the insurance company, lordship. And 5, 8, 5, 4 already appeared. 5 is the 20. Okay. 3, National Insurance Company. My learned thing is there.
Who is appearing? Same method, okay.
Services, then lordship service should be complete except 5.
What will happen to 5?
We will take fresh steps then lordship. Even the lordship may condone the delay in appeal, we can take again steps, sir.
Oh no,
Because it is, we have taken steps, but
who is 5?
5 is the driver of the other vehicle, lord. 2 vehicles are involved. Okay?
If you have taken steps, then
No AD has been received.
you take fresh steps by speed post. Heard Miss M. Chaudhary, learned counsel for the applicant. Also heard Mr. What is your name?
H does
H. Das, learned counsel appearing for respondent number 1 and 2, as well as Mr. T. Kolita, appearing for respondent number 5. Respondent number 3.
3.
3.
I'll serve.
Stop. It appears that as against respondent number 4, the office note shows that Wakalatnama has been filed by the engaged counsel for respondent number 4. However, the notice issued to respondent number 5 has not yet returned. The applicant shall take fresh steps for issuance of notice upon respondent number 4 by speed post. Respondent number 5 by speed post within 7 days from the date of this order, returnable on 15th of July. You furnished the copy of IA to other side. Yes.
Delay petition already served, lordship.
In connection with this IA petition, we have also filed another IA 3471 in this case.
3471.
Yes, Milo. Yes, Milo.
Ramesh. Yatsa.
3471.
3471.
And before my submission,
What is this?
I beg apology because without perusing the details of the IA petition, we have filed this petition. So I once again beg apology. But here actually we have paid for disposal of the amount rupees 25,000 they have deposited before the registry. So this Sampurna Bharadwaj and Sangini Bharadwaj, the respondent number 1 and 2, actually they are student, college going student, and their parents were expired. So actually they're in need of money. That is why if this
Delay is not a challenge.
No, but appeal is yet to be.
condemned,
Yes.
Appeal is yet to admit it.
delay may be condemned, my lord, because 48 days is not a.
What was the compensation granted?
Compensation granted against both the insurance company lordship, 11,65,000. And 50% each 5,82,000.
You wait for some time. They will be filing stay application. Then you make your prayer.
Okay.
Must oblige, lordship.
We'll take up this later on.
Item 24.
Lord, in this case, I'm appealing for the applicant, my lord.
Heard Mr. T. Kolita, learned counsel for the applicant, 24th. T. Kolita, learned counsel for the applicant, insurance company. Also heard Mr. H. Das, learned counsel for
2 and 3.
respondent number 2 and 3, as well as Miss M. Chaudhary, appearing for respondent number. Respondent number 6, who submits that she would be filing wakalatnama, her wakalatnama shortly.
Children kindly see office note dated 3/11/25. For service.
Now, who are appearing here? Two. You are-
2, 3 is there, 6 is there. Rest of them have received financially. Four, now remains 4 and 5 only.
On perusal of office note dated 3/11/2025, it appears that notice issued to respondent number 4, 5, and 6. Mr. Das, you are appearing for
2 and 3 respondent. Actually,
4, 5, and
respondent
1.
number 1 is the legal guardian of the respondent number 2 and 3. So it is I think it is useless at present because both of them have attained the age of majority.
Majority. Okay. Oh. Last line. Hmm. 4, 5, and 1 have been duly served. How much delay is there?
My lord, delay, my lord, 162 days, my lord.
Since the notice, service of notice on all the respondent is complete, this court is inclined to dispose of this interlock. You have any objection? Okay, you have to furnish. Dispose of this interlocutory application on the next date fixed. In the meanwhile, the applicant shall furnish the copy of the interlocutory application along with the annexures to the learned counsel for the respondents who have appeared in this case. Let this matter be listed. Agor case to kiman disile. Earlier case
15/7 actually.
15th. Let this matter be listed on 15 July.
Item 25.
May it please your lordship. This is another analogous matter, lordship. Same parties, lordship. Here is a delay of 38 days.
Service is complete.
Service is complete, lordship. Office note dated 4/11/25. Notice was issued to 1 to 4. 4 appeared, lordship. Regarding 1.
Yes.
Appeared. So, respondent number 2, AD card, and respondent number 2 not yet received, lordship. And my learned friend is also appearing on behalf of the National Insurance Company. For the 6. Okay. Here it is 2, national.
Let me Sam Chaudhary,
Yes. I do.
learned counsel for the applicant. Also Mr. H. Das, appearing for respondent number
1.
not 1. You are appearing for 3.
Sampurna Baroda.
Yes.
Respondent number 1.
Respondent number 1. as well as Mr. P. Kolita, appearing for respondent number 2, who submits that he will be filing his wakalatnama in due course. Shortly. Office note dated 4/11/2025 shows that the notice only 4 respondents are there.
Yes, Lordship, 3-4 appeared, Lordship.
The notice has been served. Notice issued to all the respondents have been duly served. Here, do you have any objection?
We have.
But
We have.
you have not yet filed wakalatnam. We'll take it up on 15th. List this matter again on 15th of July.
I have a prayer, Lordship. The another analogous matter, it is not yet listed, Lordship. Similar, arising out of same accident.
Yes.
This is filing number, Lordship, 15183, and the case number is 4007/24.
You have to make mention, so give a mention memo to list it on 15 or before that, so that notices may be issued.
This is Lordship already issued.
Okay, then
Together these cases are taken up, Lordship. This may be listed along with this, Lordship. I'm giving the number, Lordship. IA number 4007/24, Lordship.
okay.
Delay petition, Lordship.
Okay. No, these 3 we have fixed on 15th. Regarding that IA which you are mentioning, you give a mention memo, make a mention to fix that along with these 3 on 15th. You make a mention tomorrow or whenever is convenient to you for listing that along with these 3. Okay.
Then it will be convenient for us also.
As because, Lordship, notices were issued and the number is also there. Therefore, Lordship, I have paid.
Last order likhibo. As learned counsel for the applicant has submitted that there is another analogous matter, namely IA civil number
007
4007/2024 and prays for listing the said matter along with the instant interlocutory application. Registry to do so and list the aforesaid matter along with the instant interlocutory application on the next date fixed.
Applies, Lordship.
Item 26.
Your Honor, due to personal difficulty, my senior will not be able to read this matter today. Let the matter come up after some days, any other day, Lordship.
What is this?
This is condonation of delay. 27 days, my lord. There are also another item 36 and 40. So these are all similar matter and same part between the same parties.
We have filed our objection, Your Lordship.
Okay. Heard me. You are opposing. Heard Mr. D. Nandi, learned counsel for the applicant. 26, item number 26.
26, then 36.
36 and
40.
40. Separate orders. Learned counsel for the applicant. Also heard Mr. D. Nath, learned senior government advocate, appearing for respondent number
1 and 3.
1 and 3. Also heard Miss
P. Kashyap.
P. Kashyap, appearing on behalf of
Respondent number 2, 4, 5, and 6.
Not 6, I am appearing. 6 is the district collector.
2, 4, and 5, who prays for an adjournment on the ground that conducting counsel for the aforesaid respondents has some personal difficulty. The prayer is allowed. Let this matter be listed again on 15th of July.
Item 27.
Here the insurance company has already preferred an appeal. And there is an order for stay with a direction that 20% of the awarded amount be deposited. I am the claimants here. Here we have preferred this application ISC Bill 3912 of 25 for modification of the said order and allowing us to withdraw 50%. Now, the main ground of appeal urged by the insurance company is that the deceased was a government servant, and therefore there is no loss of income in view of the Assam government notification of 2017. Now, we in as claimant, when we the claimant witness number 1 appeared before the tribunal for cross-examination, that specific question was put, where I have said as a witness that my mother is not receiving any family pension. Then the official witness PW3 was also examined, and he deposed before the court that the person, that is the deceased, was an employee of the Dimahasa Autonomous Council. It's a 6th scheduled area where the Assam government notification is not applicable. Therefore, the claimants are not receiving any family pension under the scheme of Government of Assam of 2017. In view of this one, I am praying at least 50% should be directed to be withdrawn by modifying the order.
Yes, Mr.
Lordship, that 20% that we have already deposited, that may be allowed to be done. Rest is Lordship, matter for hearing. 50%, that 20% that we have deposited is almost uniformly deposited in all such compulsory family pension schemes. That may be allowed to wait.
Where is that order? Which I
27A.
number?
I number 3912.
Got you.
That order I have annexed to page 12.
You want to file objection?
Lordship, if it is 20%, then I have no objection because that is the amount we have deposited. As regards the rest, Lordship, I have objections. And that's a matter of Lordship hearing. Maybe fixed for hearing any day after receptacles, because service is also covered. We not, that's response number 6, service need not be, can be dispensed. Rest can go for it. Now that 50% modification.
That is the plea in the appeal.
That.
Main ground in the appeal.
Yes.
If we decide that issue, it will be like deciding the appeal itself. You take this 20% and we'll fix the appeal on an early date.
Only submission is that is in the judgment, there are a lot of stipulation for FDR. If that is without any rider, I may be allowed to withdraw that 8 lakh. Then, my lord, it would be, there will be some amount which I can carry.
That may be allowed.
Yes, without any rider, I may be allowed to withdraw that 8 lakh.
How much was the?
Total awarded amount is 40 lakh. 40,38,168.65.
And how many are the minors?
Now, there are total five claimants.
Claimants.
Oh. What is their age?
All are major.
All are major?
Major.
Heard Mr. E. Bhattacharya, learned counsel for the applicant. Also heard Mr. R. Goswami, learned counsel for respondent. / appellant / insurance company. This interlocutory application has been filed by the applicants / claimants in connection with MAC appeal number 394/2025, praying for alteration of order dated 27/8/2025, passed in IA civil number 2792/2025. Praying for 2025 to the extent to the extent to pay, to direct the insurance company to deposit at least 50% of the awarded amount before the registry of this court, in place of 20% as was directed, and thereafter deposit, and thereafter allow the present applicant to withdraw the same. Learned counsel for the applicant has submitted that where is the order?
Page 12, man.
That by order dated 27/8/2025, the 27/8/2025 passed in the order was passed in MAC appeal.
No, in I civil.
Make appellate person.
Both are linked, pilot. In page 11, the I civil number is given. Linked case I civil 2792 of 25.
In IA civil number 2792/2025. Directed the insurance company to deposit 20% of the awarded amount before the registry of this court as a condition for grant of stay of the impugned judgment and award, mainly on the basis of the plea of the learned counsel for the insurance company that the claimants, respondents, who are the family members of the deceased, are receiving family pension as the deceased was a government employee. Stop. Learned counsel for the applicant submits that the deceased, namely late Bigendra Sengyun, was an employee of
Forest Department, Dima Hasao, Autonomous Council.
Deceased was an employee of Forest Department in Dima Hasao Autonomous Council. He submits that as in Dima Hasao Autonomous Council employees are not getting pension.
Because they are they will get pension, but regarding this one, that compassionate family pension scheme will not cover them.
Learned counsel for the applicant has submitted that the notification of the Government of Assam as regards compassionate family pension scheme in event an employee of the Government of Assam dies in harness is not applicable to Dima Hasao Family Pension, Dima Hasao Autonomous Council, as it is governed by its own rules.
Which is deposed by PW3D official witness.
Yes. He submits that same has been confirmed by the PW3 before the tribunal while deposing as an official witness. Stop. Learned counsel for the insurance company, Mr. R. Goswami, submits that the contention raised by the learned counsel for the applicant in this interlocutory application is the subject matter of consideration in the connected appeal, and hence if any decision, any finding is taken at this stage on the said question, it may cause prejudice to the applicant, to the insurance company. He, however, submits that the insurance company does not have any objection if the money already, if the 20% of the awarded compensation which has been already deposited by the insurance company is disbursed to the claimant's respondent after verification. Stop. Finding the submissions made by learned counsel for the insurance company as reasonable, this court is also of the considered opinion that contention raised by the learned counsel for the applicant in this application has to be decided in the connected appeal only. Stop. However, as the insurance company is not averse to disbursement of the already deposited amount to the claimant's respondent, the registry is directed to disburse the 20% of the awarded amount which has been deposited by the insurance company before it to the claimant's respondent after proper verification. This, after proper verification on furnishing of a bond of the same amount, this interlocutory application is accordingly disposed of.
But may kindly add without any rider. That will
No, when I am not mentioning anything, it means that there is no rider.
when the award passed by the tribunal has 8 lakh plus 5 lakh, almost like 13 lakh rupees has been directed to be deposited in fixed deposit. Then they will deduct the proportionate amount, keep the proportionate amount, then release it. So I will get further decrease of amount.
Verification without any rider. So
Acha.
this interlocutory application is accordingly disposed.
Okay.
Oh, in main appeal,
Lordship, the service on respondent 6 is, ID card has not been received back, but it can be struck off because in this case it's between the alia. It's on quantum only. And it's the owner
and
driver.
Mr. R. Goswami, learned counsel for the appellant. Also Mr. A. Bhattacharya, learned counsel for the respondent.
125.
Respondent number 125.
5.
125. Office note dated 9/2/2026 shows that the notice, the service report in respect of notice issued to respondent number 6 has not yet been received back. Learned counsel for the appellant submits that since the issue involves in the appeal may not require the presence of respondent number 6, hence notice to the said respondent may be waived. The prayer is allowed. The notice to respondent number 6 is waived. Record I say.
And she has been received.
The records of MAC case number 2061/2022 has been received. Let this matter be listed for hearing on 25th August.
Like.
Item 28.
Service is awaited, my lord. And TCR may call for my lord.
Lord Miss L. Sharma, learned counsel for the appellant. On perusal of the office note dated dated 11/5/2026, it appears that notice issued to respondent number 1 and 2 have not yet returned. The registry is directed to place the postal track consignment report of notices issued to respondent number 1 and 2 by speed post before this court on the next date fixed. Let this matter be listed on 17 June, not 17 June, on 17 June. Let the reminder be issued for the trial court records registry to do the same list accordingly.
Item 29.
May it please, your lordship. Your lordship, service report may be awaited.
Heard Mr. S. Datta, learned counsel for the appellant. Learned counsel on perusal of the office note dated 8/5/2026, it appears that notice to respondents have not yet returned back. The registry is to place the postal track consignment reports of notices issued to the respondents by speed post on the next date fixed. List this matter again. 13th of July.
Item 30,
May it please your lordship. As per the office note dated 5th May 2026, the trial court record has been called for.
Service,
It is complete. It was completed on 3rd, 4th, 2026, your lordship.
heard Miss, what is her name?
A. Newar.
A. Neva, learned counsel for the appellant. On perusal of the office note dated 23/4/2026 as well as 5/5/2026, it appears that notice issued to sole respondent has not yet returned back. The registry is directed to place the postal track consignment report of the notices issued to sole respondent by speed post before this court on the next date fixed. The records of the trial court have also not yet been received. Issue reminder for the same registry to do this same. List this matter again.
20, right?
No, in the month of June. List this matter again on 8th of June.
Obliged, your lordship.
Item 32,
This application is filed for seeking condemnation of delay of 83 days in filing the connected appeal. And the respondent side also filed an objection in this case.
Was not file objection, but same was not taken with the record, so can we fix another date for?
Mr. A. Paul, learned counsel for the applicant, also on Miss. What is your name?
I am appearing on bill for P.
What is your name?
R. Begum.
R. Begum, learned counsel appearing on behalf of Mr. P. Kotoki, learned counsel for the respondent, who submits that the respondent has filed a written objection against the prayer for condemnation of delay made by the applicant. However, said written objection is not tagged with the case record. Accordingly, she prays for directing the registry to place the written objection along with this case record. Registry to do so. Let this matter be listed again.
22nd July.
22nd July. Iman lamba na lage. Julan gyo.
Sorry. June 19.
19 June.
Item number 33,
6 days delay in preparing appeal, and I got the appearing for the claimants. What's it here? I think he had no objection for condemnation of delay. Delay with the condom.
Mr. S.K. Goswami, learned counsel for the applicant. Also Mr. A. Agarwal, learned counsel for the respondent claimant. This application under Section 5 of the Limitation Act has been filed by the applicant insurance company, praying for condonation of delay of 6 days in preferring the connected appeal. The grounds for delay have been stated in paragraph number
5, 6, and 7.
5, 6, and 7 of the instant application. Considering the short period of delay, learned counsel for the respondent has not objected to the prayer for condonation of delay. After going through the grounds stated in the instant interlocutory application, this court is of the opinion that the delay in preferring the connected appeal has been explained sufficiently. Hence, the said delay of 6 days in preferring the connected appeal is hereby condoned and the interlocutory application is allowed. Let the registry is directed to register the connected appeal and list the same for admission after a week from the date of this order, on a date to be fixed by it. This interlocutory application is accordingly disposed of.
My name may kindly be.
Name of Mr. A. Agarwal shall be reflected in the cause list as engaged counsel for the respondent slash claimant.
Item 34.
Wait, this is your lordship. Lordship, in this case, we have taken steps only on 8/5/26, lordship.
Would be Sardi Majumdar, learned counsel for the applicant, who submits that the applicant could take steps for issuance of notice upon the respondent on 8/5/2026 only. Considering the submissions made by learned counsel for the applicant, let the service report may be awaited. Let this matter be listed again on 22nd June.
Highly obliged, lord.
Item 35.
I'm respondent number 2 in this case, madam. So respondent number 2 had filed an affidavit of opposition against the application for injunction filed by the appellant. So, my lord, in that injunction, in that affidavit of opposition, madam, there had been some type of official mistake, madam. So I have filed an IA number 872/26 for correction of those type of mistakes, madam.
Any objection?
It may be allowed, your lordship.
Why?
My objection may be recorded while passing the order, your lordship.
That you are objecting to.
Number 1, lordships, in the FAO.
No, regarding this. No, Arveta, I see. Where is the written objection?
Hello, the written objection
In the FAO.
in the IA.
Which IA?
IA 2923/25.
2923 has not been disposed of. Huh? Okay.
There is an interim order, your lordship.
Where is the objection?
No, they have not filed the objection.
You have not filed
They
them.
have not filed them.
No, this IA 2923 is for under order 39 rule 1 and 2 filed by
Lordship.
the appellant.
Yes, they have filed.
And
Yes,
in
sir.
that interim stay has been granted.
Against that, we have filed an affidavit of opposition.
Where is that? That I want.
Yes, with the order.
Affidavit in opposition. No. That affidavit in opposition is not. You see whether it is on record. Tatadyo. Because unless that is on record, you verify from the records. Records, Antok Sabadyo, Ramesh records Sabadyo. Or next item call.
May I please, Your Lord? This is an application for condonation of delay of 129 days. Lordship, on the last occasion, notice has been served to the respondent number 3, with yet to be served. But in other two connected cases, Lordship, PW has appeared. But in these cases, PW has not appeared.
My Lord, I am appearing for respondent number 3 on behalf of Mr. Jina.
She- Yes, then, Lordship.
And who is appearing for 1 and 2? One and 2 government is appearing.
Government, sir.
My Lord, we will file objection.
You'll be filing objection. Okay. Heard, Mr. What is your name?
Edeka, Lordship.
Edeka, learned counsel for the applicant. Though on last occasion, government counsel have appeared for respondent number 1 and 2. However, today no one is present on behalf of respondent number 1 and 2. Learned counsel for Miss, what is her name? Miss N. Burman appearing on behalf of Mr. D. Nath appears on appears for respondent number 3 and prays for some time for filing written objection against the prayer for condonation of delay made by the present applicant. The prayer is allowed. Let this matter be listed again on after 2 weeks on a date to be fixed by registry.
Lord.
1038.
Also an application under section 5 of Limitation Act. Last occasion they sought for time to file objection.
So my Lord, I am appearing for respondent number 3 on behalf of Mr. Jina, my Lord.
Mr. S. D. Purkasta, learned counsel for the applicant. Also heard Miss N. Burman appearing on behalf of Miss. What is the name? N. Burman appearing on behalf of Mr. D. Nath, learned senior government counsel. Learned counsel for respondent number 1, 2, and 3. What is your contention?
Objection, my Lord. We need some time to file objection.
Who prays for some more time for filing written objection against the prayer made by the applicant for condonation of delay. The prayer is allowed. Let this matter be listed after
22nd June.
22nd June.
Next,
Second. Vice.
I think in the next item also same
Same.
order. Same
39,
order.
item 39.
39, same order.
39 same order.
Same. Obviously.
Item 41.
Yes.
My lord, before my learned friend starts, here this case is filed against the United Bank of India, which is an defunct entity. And it has amalgamated with the Punjab National Bank in the year 2021. So
applicant has to first amend the post title.
Leonard brother, perhaps we'll need to see the post title first. United Bank of India, presently Punjab National Bank. There's no need to amend the cost title.
No, it is the United Bank of
That is the
India.
order. You just check the cost title of the appeal. Your lordship will.
Presently, Punjab National
Yes,
Bank.
It should be Punjab National Bank, my lord.
it is already there. You just check the memo of appeal.
Are you filing objection?
No, just in fact, I have filed a caveat in this case against the order of the civil court. And for Punjab National Bank, I had filed caveat. And the copy was not served at that time. My caveat is caveat number 239 of 2026.
Okay, otherwise also they are not going to get any relief because there is delay. First delay has to be condoned.
No, my lord, here, if I'm not
And
mistaken,
second,
already the appeal has been admitted. And the IA that is pending, that was for stay, but then on the last occasion, in fact, if your lordship remembers.
This I is for interlocutory injunction.
That IA actually was redundant on the previous occasion because of the fact that on being asked by this honorable court as to whether there is any such action on the part of the respondent bank which calls for an interim. The reply to the query of this honorable court was that there was no such action as of now. So your lordship had passed the order in the IA that in case there is any such situation arising where there is a requirement of interlocutory of interim prayer, then only that IA can be pressed. Otherwise, that IA only simply notice was issued.
Now you are pressing.
I'm not pressing. Your lordship will take.
Then we'll dispose of
We'll
this.
dispose this because as and when there situation
No,
arises.
we will take action under the Surfacy Act because we have already got order in the DRT. And since the DRT is the appropriate forum, only on that basis, the civil court has rejected the title suit.
Anyways, my
Under
lord, this
section
appeal is-
18 of the DRT Act, no other court can.
No, that question we'll decide in bill.
Then,
This
they are withdrawing the.
this I is you are not pressing.
I'm pressing I'm not withdrawing the appeal. My learned
But
is
but you are withdrawing the I.
I'm not pressing the IA.
We are disposing of the
Yes,
I.
yes, it can be closed.
Heard Mr. Edhar, learned counsel for the applicant. Also heard Mr.
A Parvez.
A. Parvez appearing for
Punjab National Bank.
Punjab National Bank.
I had filed a caveat 239 of 2026.
You are appearing for Punjab National Bank.
Yes.
Who submits that this interlocutory application has been filed in the name of United Bank of India. However, he submits that since the said bank has merged with Punjab National Bank in the year 2021, the appeal as well as the interlocutory application ought to have been filed in the name of Punjab National Bank. He further submits that in this case, he has also filed a caveat. However, since name of Punjab National Bank was mentioned as caveator, therefore he submits he had not received the notice. Stop. On the other hand, learned counsel for the applicant submits that though this appeal has been filed in the name of United Bank of India, however, in the cause title of the memo of appeal as well as in the interlocutory application, it has been specifically mentioned therein that the said bank is presently known as Punjab National Bank. Stop. Be that as it may, learned counsel for the applicant has submitted that he is not pressing the instant interlocutory application. Hence, this interlocutory application is dismissed on not being pressed. Appeal some. Records I send. Records. You accept notice on.
Yes, I will accept, and my name should be shown in the proceeding.
And Mr. B. Chakravarti.
D. Chakravarti.
A.
D.
D. Chakravarti, learned counsel for the appellant. Also, Mr.
A. Parvez.
A. Parvez, who appears for the respondent number
1 to 6.
1 to 6.
1 to 5. Oh, 6 is by me. 1 to 5. Punjab National Bank. And
1 to 5. However, he also submits that the appellant herein, the respondent herein, namely United in the United Bank of India has no existence at present, as same was merged with Punjab National Bank in the year 2021, and he has been engaged by Punjab National Bank only. However, he accept notice on on behalf of respondent number 1 to 5. You have not taken steps against other respondents.
it's not dated 31/3/2026. Service report may be awaited on the other. It has already been dispatched. There is no report.
Sir, you have taken steps or not?
Yes, my lord.
But there is no reflection that
Your lordship will kindly see in the office note dated 31/3/2026. The mode of dispatch is mentioned. Insofar as respondents number 6 and 7 are concerned, that is
31/3/2026 only mentions about the requisition of trial court records.
my lord, so far the service report is concerned, that is in the main appeal.
Yes, I am seeing main appeal only.
A copy of something in the interlocutory of application. Your lordship.
Okay. Office note dated 31/3/2026 in the connected interlocutory application shows that notice issued to respondent number 5 to 7, 6 and 7 by speed post have not yet returned. The registry is directed to place postal track consignment report of notices sent to the respondent number 6 and 7 by speed post before this court on the next date fixed. It shall also issue a reminder for the trial court records. Let this matter be listed. 17.6.
The only thing is regarding this disposal of the IA. My lord, there was an order, the last order in the IA itself, that in case of there being
Yes, I am good.
my lord, my name should be shown in the court.
Name of Mr. A. Parvez may be reflected in the cause list henceforth as engaged counsel for respondent number 1 to 5.
Item 35.
My lord, it is not on record. We have filed it on 5/12/25.
Where it is? Ramesh, ये record to them. Which record?
Affidavit of position matter. IA 2923/25.
It has to be called for your lordship. It is not on record, your lordship.
It is not on record.
Not on record.
Okay.
But filed on 5/12/25, document number 92/2025.
5?
On 5/12/2025. 5th December 25.
यार बताइए.
IA 2923.
2923 is for
Injunction matter. 2923 for injunction matter, order 39, In that case, we have filed the affidavit in opposition.
in IA 2923. Heard Mr. S. Heard Mr. S. A. Hussain, learned counsel for the applicant. Also heard Mr. S. Sharma, appearing for whom?
Respondent number 2.
Respondent number 2.
Number 1.
And Mr. F.U. Borbhuya, appearing for respondent number 1. Learned counsel for respondent number 2 has submitted that respondent number 2 has filed a written objection against the instant interlocutory application filed by the applicant on 5/12/2025 and has produced the acknowledgement receipt given to him by the registry in support of his submission. However, it appears that said written objection is not yet placed on record. The registry is directed to place the written objection filed by the applicant, filed by the respondent number 2, along with this interlocutory application. Filed by the respondent number 2 with along with this interlocutory record of this interlocutory application on the next date fixed. Let this matter be listed again on
June.
19th June.
19.
There is an interim order that may be continued till then.
19 June. The interim order shall continue till next date. This amendment petition will be considered only after it comes list accordingly.
Item 42.
May I please, your lordship? According to office note dated 11/5/26, no ID card has been received yet. So registry may also be kindly directed to attach the postal consignment.
Heard Mr. A. Agarwal, learned counsel for the applicant. On perusal of the office note dated
11/5.
11/5/2026, it appears that the service report in respect of the notices issued to the respondents is awaited. The registry is directed to place the postal track consignment report of notices issued to the respondents by speed post before this court on the next 8 weeks.
19 June.
Let this matter be listed on 19th of June.
Item 43.
Meet with your lordship. Lordship, this instant I has been filed for continuation of delay. On the last date, notice was issued, lordship. Thereafter, we've taken steps. Lordship may kindly peruse the office note sheet dated 8/5/2026, lordship. With respect to the service upon the respondent number 1 and 2, lordship, answered notices have been returned back. Insufficient address, lordship. And with respect to the respondent number 3, lordship, neither AD nor answered notices have been received. The lordship may allow us to ascertain the address of the respondent number 1 and 2, lordship, and then take fresh steps in the matter.
Heard Mr. What is your name?
Lordship, HR Das.
H.R. Das, learned counsel for the applicant. On perusal of the office note dated 8/5/2026, it appears that notices issued to respondent number 1 and 2 have returned with postal remark within inverted comma insufficient address dot return to sender inverted comma close. Whereas notice issued to respondent number 3 has not yet returned. The learned counsel for the applicant prays for some time to find out the correct address of respondent number 1 and 2. Prayer is allowed. Registry is directed to place the postal track consignment report of the notice issued to respondent number 3 by speed post before this court on the next date fix. Let this matter be listed again on
July.
13 July.
Okay. Item 44.
May I please appeal? Lordship, this delay condemnation petition,
Yes.
139 days. And we file our objection on that today.
Heard Mr. S.C. Das, learned counsel for the applicant. Also heard Mr. What is your name?
M. Smith.
M. Smith,
Yes.
learned counsel appearing for the respondent side, who submits that the appearing for the opposite party stop, who submits that some time may be granted to the opposite party for filing written objection against the prayer for condonation of delay. You are appearing for all the respondent opposite parties. Stop. The prayer is allowed. Let this matter be listed. 2 weeks.
15 June.
15 June.
Item 45.
My lord, kindly allow us 1 week time to take steps.
Take steps.
No, madam. They are not taken step by you come to learn cases in file, so you file a that's another 1 to 5.
Or all.
1 to 5. 1 to 5.
6 to 7 years.
How many respondents are there?
Claimants, 7 respondents.
7 months.
They are the driver and owner, and I am the where claimants.
So all have appeared.
All have appeared. But filing of after filing, they are not taken any steps.
We have to learn that from the concerned court that
Last order
Yes,
was
sir.
only 13,526.
You have saved the money.
Easy correct.
They might have only 24 days.
Are you opposing? Heard Ms. L. Sharma, learned counsel for the appellant. Also Mr. J. Ahmed, appearing for respondent number 125/claimant, as well as Mr. S. Islam, appearing for respondent number 627. This interlocutory application has been filed by the applicant insurance company under Section 5 of the Limitation Act, praying for condonation of delay of 24 days in filing the connected MAC appeal. The learned counsel for the opposite parties have not opposed the prayer for condonation of delay, considering the short period of delay involved. I have gone through the grounds stated by the applicant in the interlocutory application. It appears that delay has been sufficiently explained by the applicant. Accordingly, the delay of 24 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry shall register the connected MAC appeal and list the same for admission on 15 June. You furnish the the learned counsel for the applicant is requested to furnish the memo of appeal along with annexure to the counsel for the other side. Registry is directed to reflect the name of name of the learned counsel for the respondent as indicated herein before in the cause list henceforth.
Item 46.
Please, kindly see office to dated 8/5/26. Notice and on respondent number 1 has been duly served. So far as respondent number 2 is concerned, neither ID card nor answer notice has been received. Lordship, so far as respondent 2 is concerned, his appearance is not necessary, Lordship. We have challenged quantum only in the connected thing.
His appearance may not be necessary in appeal, but
Lordship.
in condonation application, he has a right to oppose.
Respondent number 2, owner
Oh.
debate.
And who are you?
I'm claiming
Insurance company notice is served.
notice served, not appear.
We'll give one more date and direct the registry to place the postal track consignment. Heard Mr. M. Talukdar, learned counsel for the applicant. It on perusal of the office note dated 8/5/2026, it appears that the AD card sent along with the notice to the respondent number 2, respondent number 1 has returned with seal of the respondent number 1 insurance company thereon. Accordingly, the notice issued to respondent number 1 is held to be duly served. As regards respondent number 2, the service report is awaited. The registry is directed to place the postal track consignment report of notice sent to respondent number 2 by speed post before this court on the next date fixed. Let this matter be listed again on
15/6.
15/6.
Item 47.
Wait, this is your lordship, we have taken steps only on 11/5/26, lordship, so.
Miss R.D. Majumdar, learned counsel for the applicant. Let the service report in respect of notices issued to respondents be awaited. Let this matter be listed again on
19 June,
19 June.
Highly apply.
item 48.
Lordship, I am appearing on behalf of respondent number 1. They have filed the wakalat number yesterday only.
Lordship, regarding respondent number 2 and 3, Lordship, not returned yet. Lordship, 3 has been unserved, Lordship. Respondent number 3, it's been returned with insufficient address. And regarding 1, they have appeared, and 2 is awaited, Lordship.
So what is to be done for 3?
3, to take first steps, or Lordship, you
Mr. P.J. Burman.
you can try for the correct address.
Heard Mr. P.J. Burman, learned counsel for the applicant. Also heard Ms.
S. Patwari.
S. Patwari, learned counsel for respondent number 1, who submits that she will be filing her wakalatnama. Sure.
Yesterday.
She has already filed wakalatnama for respondent on behalf of respondent number 1. On perusal of the office note, it appears that notice issued to respondent number 3 and 2. You are appearing for?
Respondent number 1.
2 have. No, it appears for
3,
from office note dated 8/5/2026 that notice issued to respondent number 3 has returned with postal remark insufficient address returned to sender. Learned counsel for the applicant has prayed for some time to the applicant so that it may find out the correct address of respondent number 3. Prayer is allowed. The registry is also directed to place the postal track consignment report of notices issued to respondent number 2 by speed post before this court on the next date fixed. Let this matter be listed again on
27 July.
27 July.
Obligation.
Item 49.
Here I have filed one interlocutory application for modification of the order dated 8/11/2023, passed in ISC bill number 3281/23. Here stay is granted without any direction for deposit.
AIA to the auction. The IA has been disposed of.
Yes. I have annexed the order, page 10.
Yes, Mr. Husan.
It will be allowed subject to furnishing in any bond because it has been claimed as a death case without postmortem report. Death has occurred 20 months after the accident. So I think is entitled to an injury claim. That's a dispute lawsuit that may be allowed subject to furnishing in.
But you should have pointed out to the court when court was giving absolute stay without issuing notice.
I have made that kind of a submission, that it's an injury case, but no postmortem and it occurred. There is no connection between date. That's my point. There is no medical record after a certain point of time. That was my point while explaining that there is a connection between the date and the accident and the injury is not accepted. That was my point. Yeah, this can be allowed as a subject to action now.
Mr. A. Bhattacharya, learned counsel for the applicant, all applicants. Also, Mr. R. Goswami, learned counsel for the insurance company, namely ICICI Lombard General Insurance Company. What will happen to notice to other respondents?
Lordship, sorry, Lordship, I could not take justice service on the harassment 2 and 4.
And
They will not be required in any case, Lordship. It's basically between two of us, whether that injury is the cause of death. So that can be dispensed.
in IA number 500, 1500, A order to IA 1526. This interlocutory application has been filed by the applicants / claimants in connection of the MAC appeal number 400/2023 seeking alteration of seeking modification of the order dated 8/11/2025 passed in IA civil number 3281/2023.
My lord, 8/11/2023.
8/11/2023 seeking modification of 2023 passed in IA civil number 3281/2023. Learned counsel for the applicant submits that in the aforesaid interlocutory application, that is IA number 3281/2023, which was filed by the insurance company, the court, without issuing notice to the opposite party, has stayed the execution of the impugned judgment and award dated 24/7/2023 without imposing any condition, and therefore he submits that the same may be modified and the insurance company may be directed to deposit at least 50% of the awarded amount. And counsel for the respondent insurance company fairly submits that since no notice was issued to the present applicant in the aforesaid interlocutory application, he does not have any objection if the insurance company is directed to deposit 50% of the awarded amount as a condition for grant of stay. Stop considering the submissions made by learned counsel for the applicant as well as insurance company. The order dated 8/11/2023 passed in IA civil number 3281/2023 is modified to the extent that the stay of execution of the impugned judgment and award granted by the said order shall further continue subject to deposit of 50% of the awarded amount by the insurance company before the registry of this court within a period of 4 weeks from the date of this order. Stop. On such deposit, same shall be disbursed by the registry to the claimants / applicant after proper verification on furnishing a bond of the amount to be disbursed to them.
Lordship may kindly add without any rider. There you go.
And there is no rider. Comma without any rider. This interlocutory application is accordingly disposed of. Appeal, main appeal. Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. A. Bhattacharya, learned counsel for respondent claimant.
1 and 2.
Number 1, 2?
1 and 2.
1 and 2. Learned Mr. R. Goswami submits that you could not take steps, that the appellant could not take steps by thus mode for service of notice on respondent number 3 and 4. However, he also submits that since considering the contention raised by the appellant in the memo of appeal, the presence of respondent number 3 and 4 may not be necessary. Hence, he prays for waiving the notice to them. Prayer is allowed. The notice to respondent number 3 and 4 is hereby waived. Let the records of connected MAC appeal be connected MAC case. No, let the registry to issue, not let, registry to issue a reminder for requisitioning the records of MAC case number 850/2015 from the concerned tribunal. Release this matter again on
7 July.
27 June.
Apply.
Item 50.
May it pleases your lordship, my lord. My lord, here, my lord, the condemnation application, my lord, in the IA, my lord, there is a delay of 18 days, my lord, while preferring the my lord, matrimonial appeal under section 28 of the Hindu Marriage Act, my lord.
But Mr. B.K. Das,
My lord.
learned counsel for the appellant. This interlocutory application has been filed by the applicant praying for condonation of delay of
18 days.
18 days in preferring the connected matrimonial appeal. Issue notice to the respondent.
Since there is sole respondent, my lord, lordship may issue a short notice, my lord. I will take speed post, my lord.
Issue notice to the respondent. And it is a divorce case.
Yes, my lord.
Granted or?
My lord, the husband sought divorce, my lord. This is dismissed, my lord.
And why are you praying for short date? You want early relief.
Because my lord, marriage already broken, my lord, they are living separately. Wife also stated before the honorable court in a deposition for last 7 years they are not together.
You waited for 7 years. I was wondering why you are praying for short date. Let the notice be issued to the sole respondent. The appellant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order. After 4 weeks. No, June on the.
But 15th of June. 15th June. Yes.
15 June.
Mala obliged, deeply obliged.
Supplementary item 51.
There, please, your lordship.
Yes.
Should may kindly fix this matter for hearing.
Hearing ready.
No, lordship. The cross objection has to be admitted, lordship. It is also tagged to the main appeal.
Cross objection, sir.
There are the hearing.
Cross objection is barred by limitation.
No, sir, lordship, because this appeal was dismissed. This was dismissed and again they filed a petition, then it is registered. And I have given liberty in this land court lordship. That I can file the cross objection lordship.
No, but it has to be within the period of limitation.
Yes, lordship. But their appeal was dismissed and it was readmitted, lordship.
No, maybe, but when you are, you may file an appeal on your own or cross objection, provided it is within the period of limitation.
Order 41 in the date fixed for hearing, lordship. Order 41 rule 22, lordship.
What it says.
It says. Notice of hearing, lordship. 30 days from notice of hearing, lordship.
Order 41 rule.
22.
Read.
दोनों की तरफ
Okay. No, on 9/1/2026. It is already ordered that
Yes, lordship.
the question will be decided at the time of hearing.
Hearing.
Maintainability.
And
In view of the order passed in, no, heard Miss D. Hajurika, learned counsel for the appellant. Also heard Mr. A.R. Agarwala, learned counsel for the respondent, as well as for cross-objector. It also appears from record, that this miscellaneous first appeal is ready for hearing. It also appears from record that by order dated 9/1/2026, it was directed that the question of maintainability of the cross objection on the ground of limitation will be considered at the time of final hearing of the connected MFA. Therefore, let both the matters be tagged together and listed for hearing on 27th of August. The question of maintainability of the cross objection shall remain open. Remaining leftover.
Submission. I think 56, my lord. This is 11 years almost. I have got nothing, though claimant, I'm an widow. So we have filed a vacation petition for being stayed the order by the under MSC tribunal. So that order may be vacated and we may be given some, at least 50% of the ordered amount. That is the only prayer. Since almost 11 years, I have got nothing.
56. Oh, no, what is there in 56?
I believe that 52. 52. 52.
I have to dictate
Yes, yes.
some judgments in chamber.
Well,
So I cannot remain here.
next week, 52.
We are fixing a short date.
Yes. Next week.
Leftover matters, short dates will be fixed.
Yes.
Ramesh,
Day after tomorrow.
the
56.
courtmaster will give date. Record side date. Don't pressurize him.